everyone, and welcome to Crime in Court. This is the 1993 Menendez brothers trial, California versus Erik and Lyle Menendez, on trial for the homicides of their parents. We are doing a trial transcript read through because unfortunately we don't have video. Judge Weisberg decided not to allow cameras in the courtroom for whatever reason in the second trial, and it's already causing problems. And we're now on day 3 of the trial, October 13th, 1995. Um, and so day 3, or at the end of day 2, Leslie Abramson, the defense attorney for Erik Menendez, decided that she wanted to get a gag order on the defense attorney or on the prosecution so that they couldn't be talking to the media they spoke with the media. Apparently she claims that they spoke with the media in the morning before court started, during their lunch recess, and then after the afternoon session. So that's 3 times a day the prosecutors were updating the press about what was going on, even though the press were in the room. The press had access to go in. It wasn't like it was closed to the press. It was an open public trial. They just didn't allow cameras. So press were still allowed. So, but whatever the prosecution was saying, Leslie Abramson accused them of kind of, spinning the story their way. And of course, they feel like they need to correct the record. So there's already this going back and forth between the two sides. There's already a lot of tension between Leslie and Judge Weisberg, the only two people who returned from the first trial, and the only two people who butted heads well, not the entire trial, but often butted heads during the first trial. And they had to return and work together on the second trial, which I just find I I really sympathize for Leslie, because as I was watching her, as we streamed the first trial, it was very frustrating seeing the way that he ruled often in the favor of the prosecution, and he often argued back and forth with Leslie and didn't let her make her arguments. And it seems like that's already kind of continuing on in this trial. So we're also reading through um, the arguments between attorneys and the judge when the jury's not around, so you guys can get an idea of, the environment. I think it really does lay down a picture of how the judge does treat them differently. He treats the prosecution very, professionally. And then I feel like when it comes to Leslie, he cuts her off. He's very curt and doesn't want to deal with her, is kind of how I feel, is the vibe coming off the page. So let's get started with the reading. We are on part 3 of the state's case, and we're going to go as many parts as it takes to get through. I'm allowing you guys to pick the witnesses. So actually, while I'm talking about that, let me pull this up. So I have shown you guys that you have access to the trial transcripts, the whatchamacallit, um, here. So you've got access to the 1996 trial transcripts, which we'll show you in a second. The appellate and resentencing documents. Those are all the things that are going on now, currently with the case. To get the habeas corpus petition is in there. The resentencing docs are in there. So those, all of that's in there if you ever want to go back and look at it on your own time. So I added recently in the October file. So we've got week 1 and 2 are in here for your review if you want to look through it, whatever. All right. So then the thing that I wanted to bring your attention to is this witness list, which I'm giving you guys a link down below in the description for all of these things. You guys can access it anytime and follow along, download them, whatever you want to do. So this spreadsheet that is coming up, I put together for you guys. I went through all the transcripts and I wrote out all the witnesses, in the order that they go in, and what dates that what dates that they are on the stand, so we can kind of pick and choose which ones we're going to go through. So we've already read through the prosecution's opening statement, the defense opening for both Eric and Lyle. That we have one jury this time, which is a big difference from last time. We had two separate juries, one for Eric, one for Lyle. This time, one jury for both of them. Still two separate attorneys. Um, Sets of attorneys, I should say. So we did the opening statements for Eric and Lyle, and then we are right now currently on October 13th of Detective Leslie Zoeller. He is the lead detective of this case from the Beverly Hills PD. We're going to go through him. You guys voted, and I heard you. So we're going to read through all of it, and all of his testimony, both direct and um, cross. And then look out for, on my page, there's a poll for whether we should read Christine Nye. She is the dispatcher. She's the one that answered the 911 call from Lyle Menendez. Let me know if you want to hear from her or if you want to skip it, because if it's not interesting, or I want this to be for you guys. So if you don't care, we can skip it. If not, I'll read through it. After her is going to be Michael Butkiss. He is a PD officer with Beverly Hills, and was it him who interviewed? I thought it was Sergeant Edmonds that interviewed the brothers. One of them interviewed the brothers. We're going to hear from Michael Butkus and Sergeant Thomas Edmonds. I can't remember now, but I will have you guys also do a poll for that. For Avril Crom, she's the neighbor that heard gunshots. We'll do a poll for that as well. As far as like key witnesses or people that didn't testify in the first trial but are here in the second trial, I'm going to do those. So Perry Berman, he was a key witness. He was used for the brothers' alibi, and we will read through his testimony. Clara and Randolph Wright are going to be new witnesses that we didn't hear from in the first trial, so we will definitely read through that. And then Carlos Baralt, uncle of the brothers, and then Howard Whitkin was the IT consultant. I consider those pretty key witnesses, so I'll go through their testimony as well, and that'll get us through week 2. So it's gonna be a ride. So it might be a little while to get through some of this testimony, but I feel like I can get through a day in about 4 hours. So we'll see how that goes. All right. So without further ado, let's get started with the continuation of Detective Leslie Zoeller, lead detective in this case, on the stand, and he is going. This is direct, so Mr. Khan is going to be doing the questioning, if I recall. All right, so the court says you're not missing anything. It just says up here that they read through some pages, so I don't know if that's how relevant that is, but they read through some transcript pages that were sealed, and we don't know what they were. But then the court brings everybody in. He says, in the trial, the defendants are in the court, their lawyers are here, and the prosecutors are here. Something you want to talk about? He asks, and Miss Najera says, or Nahara, I'm not sure how to pronounce it, so if I flip-flop back and forth, that'll be a fun ride. All right, so Miss Nahara, just briefly, Your Honor, I am, Miss Nahara says, just briefly, Your Honor, I've been talking to counsel for the defense, and apparently there's an issue involving discovery. Counsel stated that in her opening statement, Mrs. Abramson, that they would be presenting to the jury results of tests and physical and mental examinations of the defendants, as well as physical examinations of the crime scene, whatnot. We have not received, I believe, all of the curriculum vitae of all their experts, nor have we received any reports of any of these tests and things that were done. I asked counsel about that. She said, well, we haven't finished doing whatever it is that they need to do, and she didn't know when they would be finished doing whatever it is that they need to do to get a finalized copy. So that wasn't very specific, now was it? Ms. Nahara says, we'd like the court to have a date so we can get all this stuff. That's a very professional line there, this stuff. Court says, and what's the defense response? Ms. Abramson says, the defense response, for reasons this court is well aware of, we haven't been able to complete our evaluation of the crime scene evidence. And what I told Ms. Nahara was that with respect to that, we believe that at this stage, the information we have from our experts is impeachment evidence and that we need not turn that over this far in advance. So impeachment evidence doesn't need to be doesn't fit that requirement of the deadline for discovery. I guess you can turn it over later, is what she's saying. And as far as the direct evidence of their own findings, as the court knows, we haven't had the opportunity yet to complete our evaluation of all of that evidence. And when we have a final report of that, which is not, the two are so closely linked, it's hard to segregate out what is not impeachment and what is our own evidence. But when we have something discoverable, we'll give it to them. But all of this has been done, as the court knows, on relatively short notice, and we're not finished. As far as our psychological experts are concerned, they got the report years ago from Dr. Maloney, so there's nothing surprising there. And they have the CVs on Mr. Morton. They have the CV on Dr. Fackler, and I believe they have the CV on Dr. Wecht. And if you don't recognize these names, that's because they are new expert witnesses. I'm not sure why they had to get all new expert witnesses and whatnot, but they chose to go a different route. Maybe their other experts were. I mean, I don't know how the prosecution could get them to not testify. I don't know. They had some really good experts in the first trial, if you recall. We went through a lot of them. I mean, we went through all of them, but they had a lot of testimony. All right, let's hold on one second. I need a sip of water. And a back. All right. If you don't mind, please hit the like button. I always forget to say that at the end, or say it at the beginning, and at the end, I feel like you guys are already clocked out. So, all right. So, another thing that I wanted to say that I forgot to say earlier in my video last week, or earlier this week, I should say, is there's a fire near the Brothers prison near Richard J. Donovan Correctional Facility, which is near the Mexico border, kind of close to like nearest U.S. city, San Diego. Nearest city is like Tijuana. So they're kind of close to where the recent fire that broke out in the southern border, which is on the California-Mexico border. They never quite were in the evacuation area on the map, but they were quite close. But it seems like it has rained over the weekend or over this past weekend, and it seems to have slowed down. Who knows? By the time this actually goes, there might be some new change in the news. So, but hopefully that continues to improve and the fires are put out soon in California. All right. So let's continue on. Ms. Abramson is saying here, as far as our psychological experts are concerned, they got the report years ago from Dr. Maloney, so there's nothing surprising there. Okay, sorry, I read that paragraph. Ms. Nahara says, Your Honor, I don't believe we have Dr. Weck's CV, and I understand Dr. Maloney did some psychological testing, but we've never gotten the results of those. Ms. Abramson said she was going to be calling these witnesses and presenting this before the jury. We have not seen them. Ms. Abramson replies, "We've been through this before. We do not have to turn psychological tests over." Ms. Nahara says, "I understand that." Ms. Abramson says, "Until we put them on, and we're a long way from that, but they do have Dr. Maloney's report. They've had that all along." The court says, "So what are you asking for?" Ms. Nahara says, "We're asking for any reports on any tests that were done on the defendants, psychological or physical, which counsel said she would be presenting, as well as any reports on anything done physically with the crime scene." The court says, "Psychological reports, you're asking specifically for the results of the psychological tests?" "Correct, Your Honor. I understand that one of the defendants has had an MMPI or something along those lines, and I don't know what other tests there are out there, quite frankly." The court says, "Okay, all right, and this was not litigated during the hearing on discovery, was it?" "I don't believe so, Your Honor," says Ms. Nahara, and Ms. Abramson says it was turned over. The court says, "No, she's asking about the results of the psychological tests." Ms. Amerson says, "Well, the specific results of the tests, the report refers to the results of the test." "Well, what about the test results themselves?" Ms. Amerson says, "They're not entitled to the test results." Court says, "What is your authority for that?" Ms. Abramson says, "Well, Your Honor, we can have a hearing on this with authority, but my reading of," and the court cuts her off again. "All right. You can, on Monday. Without consuming more time now, on Monday, you can provide me with any authority you have for the proposition that the people are not entitled to the results of the psychological tests, and the people can provide me with authority indicating that they are entitled to it. As far as the CV, that has not been provided. Obviously, it should. As far as the crime scene analysis that deals with the defense response to the proposed testimony of Dr. McCarthy, the defense is in the process of working on that and hasn't completed it yet. So there's nothing for them to turn over." Mr. Gessler says, "There is one more matter, Your Honor." The court says, "At this point, until they have finished their work, at least." "Yes." Mr. Gessler says, "At the close of the court yesterday, I mentioned my concern that the jury might think that certain comments related by Detective Zoeller to Lyle Menendez, purportedly coming from Marcy Eisenberg and some others from Perry Berman, might be accepted for the truth of the matter asserted therein. We have proposed a statement or an instruction by the court to cure that. The district attorney has certain objections to it, feeling that it might not allow the jury to consider adoptive omissions, and we're trying to work out a compromise. I think we can do that. Do you have a copy of the instruction that we had submitted?" The court says, "I do. I brought it into chambers, so I don't have it in front of me, but is it something that has to be done right now, or can it be done after these tapes have been played?" Mr. Gessler says, It can certainly be done after the Lyle Menendez tape has been played, and I presume it can be done after all the tapes have been played. I presume that's what's going to happen. That would probably take care of it." The court says, "Bear in mind that the jurors will later on have more access to these tapes during deliberations and have better opportunity to appreciate the instruction once they actually utilize the tapes in deliberations, so they'll be more than happy to deal with it, but I don't think it has to be done it doesn't have to be done right this second. But I agree with you. If it's something to be done, it should be done during the same time frame in which the tapes are played sometime today." Mr. Gessler says, "All right." Ms. Abramson says, "I would also ask the court if the court would consider watching the evening news tonight and get a glimpse of Mr. Khan's press conference from this morning And then the court will understand when I file the writing that I will be on Monday what the problem is. The court says, okay, any particular channel that you had in mind? Ms. Abramson says, I don't know. I think he was holding a generalized press conference talking about how he changed our defense or how we changed our defense and talking about kneecapping and all of that stuff. Well, that's totally inaccurate if he was talking about that. I mean, not talking about it. In fact, what is happening in court? All spin, and I don't know which channels will cover it. They're all here all the time. Mr. Gessler says, the thing that's my greatest concern about the press conferences is not, although a spin on what happened in court is one thing, what bothers me the most is anybody talking about any evidence that has yet to be presented or presumed evidence that never will be. The media's interest often seems to be in things that have been ruled inadmissible by the court. See how that happens all the time? So the prosecutor is going to the media and saying things that might not be admissible in court, but you can get that to the media and spread other ways. And then by public perception, it becomes fact, you know, which seems to happen a lot of times in our like true crime lore, you know. It'll just become a fact even though it may have never happened. All right, so the media interest often seems to be in things that have been ruled inadmissible by the court or the district attorney has in his own mind viewed as not having significant admissible value. To have that out on the airwaves or to be asked questions about that and stand there and say no comment or something like that, or worse yet, to comment on things that have not yet been presented and may not be, is what I feel has some potential value to influence this jury, even inadvertently, and harm the case. Spin we can all put on things in final argument. That doesn't bother me as much. Court says, all right, well, obviously, commenting on evidence that will not be received or has been ruled inadmissible for legal reasons would be subject to substantial questioning as far as why any lawyer involved in the litigation would be doing that. Mr. Gessler says, we're talking about, for instance, anything concerning the failure analysis which we have yet to be presented in court. And then the court cuts him off and says, well, let me stop here because it's a rather generalized conversation and it's consuming time that we could deal with the jury. And you told me that there was something I should see on the news tonight, and Ms. Abramson indicates that she's going to file something in writing and we can deal with it further. It's not something that will be forgotten, but I don't think we have to deal with it right this second. Mr. Gessler says, very well, Your Honor. The court says it's a legitimate concern, however. Ms. Abramson says, thank you, Your Honor. The court says, all right, let's have the jury out. So the jury comes and enters the room. The court says, morning. Before we get started here, let me just ask, as I will throughout the trial, if any of you have seen or read anything. Okay, blah, blah, blah. One person has. Oh, okay. So the question was, any read anything in the newspapers or anywhere about it? And one person says that they have. Is that something is done recent in the last 7 days? The alternate juror, it's an alternate, says, yes, it was. The court says, where was it at? And then they say, myself, I saw the attorneys on TV. And as soon as I saw it, I had my wife turn it off, just a small glimpse. So, very valid argument there for Mr. Gessler and Ms. Abramson as they argue for a gag order against the prosecution because the juror saw them on TV. The court says, did you hear anything that was said? Alternate says, no, just saw the face. Court says, which lawyer did you see? I think it's Mr. Khan. I know it's that gentleman. I'm just not sure if that's his name. The court says, will that influence you at all? He says, no. And you didn't hear anything that was said? No. Okay, anybody else? And again, throughout the proceedings, It's very important that you not listen to or see anything, blah, blah, blah. The evidence that's received, whether it's physical, direct, okay, things that occur outside the courtroom are not in any way to be considered by you in deciding this case because it's untested and it's not part of the trial process. So please continue following the directions I've given you. We'll resume with Detective Zoeller. He gets on the stand. The court says, I'll remind you, you're still under oath. The witness says, yes, Your Honor. Mr. Khan begins his questioning. At this time, we'll continue playing the tape, Your Honor. The court says, okay. The tape left off, I believe, at the end of page 17. Okay, I'm sorry. I'll give you transcripts before we do that. Okay, we all have the transcripts. You may play the tape. So they pass out the transcripts. Tape's been played. Now, direct examination. All right, Mr. Khan says, is that recording that we listened to a true and accurate recording of the interview that you conducted with Lyle Menendez on September the 17th of 1989? By the way, I looked for that. I couldn't find it. I did find a more recent interview of Detective Zoeller being interviewed by the media, which I will eventually play on the channel. We'll go over that. All right, so he says, yes, it is. And the transcript that you have in front of you, which has been marked as People's 51 for identification, does that appear to be an accurate transcript of that recording? I'm going to object, says Ms. Abramson. The jury is here. The jury can hear it and see the transcript. The court overrules yet again. The witness says that we can hear yes, or what we could hear yes. Dr. Khan says, all right, now, after you conducted your interview with Lyle Menendez, did you also speak with Erik Menendez that same day? Yes, I did. And can you tell us how that interview came about? After the interview with Lyle, Erik had come downstairs from, I believe, from taking a shower, and we interviewed him in the same room, also tape recorded. Once again, your partner, Detective Leinhart, was there for the interview? Detective Linehan. Detective Linehan, I'm sorry. At that time, was he or wasn't he? He didn't answer the question. You just corrected him. At that time, was the tape recording also placed in a position where the defendant could see it? Yes, it was. It was on a coffee table between the three of us. And do you recall where Lyle Menendez was during the course of that interview? He was in another portion of the house, I believe the kitchen area. And as far as the people that you went there to speak. Wait, sorry, hold on, back up. And as far as the people that you went there to speak with that day, that is Carlos and Terry Baralt, where were they during the time of the first interview with Lyle? They were in another part of the house. Okay, and during your interview with Erik Menendez, where were they? Also in another part of the house. Mr. Khan says, okay, at this time, Your Honor, I have a tape recording which I would like to mark as People's 52 for identification. The court says yes, Mr. Khan says, and I also have the transcript which I would like to mark as People's 53 for identification. There were exhibits used in the first trial, were they? Ms. Nahara says no. And Mr. Khan says, no, actually, the court was asking if those were, sorry, the court asked these were exhibits used in the first trial. Ms. Nahara says, no. Mr. Khan says, no, actually, neither of these exhibits were used in the first trial. Showing you People's 53, Ms. Abramson says, wait, could I have a moment, Your Honor? Attorneys Abramson and Nahara discuss. All right, so next question by Mr. Khan. Showing you People's 53, have you had an opportunity to previously review that transcript? Yes. And does that appear to be a true and accurate transcript of the conversation that you had with Erik Menendez on September 17th of 1989? Yes, it does. I will play this tape recording and ask you some questions about it after we have finished playing the recording. Once again, In regard to this transcript, which is in front of you now, that is, People's 53, there is some notation in the transcripts identifying the speakers. And can you tell us once again what that notation refers to? The L designation is for Detective Linehan, my partner. The Z is for myself, Detective Zoeller. The M is for this time it's Erik Menendez. The U is for identified person, and then the three asterisks are unintelligible words or speakers within the transcript. Okay. All right, Your Honor. At this time, I would ask that the bailiff collect the old transcripts and distribute the new transcripts. Mr. Khan says once again, we will stipulate that the court reporter need not transcribe this. Unfortunately, now we don't get to know what it is. It might be out there somewhere. I didn't do a total deep dive on the exhibits for this, but maybe they're out there. If somebody has a good website with all the exhibits for this trial, that would be phenomenal. All right, so Ms. Abramson says, Your Honor, at this point, we have to object and ask to approach. The court says, What page are we on? Ms. Abramson says 30. What line? I can't give you a line site right now. I just want to bring, it's just there's something missing that we suddenly realize has been redacted. It shouldn't have been. You know, or you won't be able to understand by just looking at what's here. I simply want to call it to the court's attention. The court says, well, if that's the situation, let's just deal with it and we can deal with it later. Or let's just finish it and we can deal with it later. Like, why? He wants to always deal with everything later. Like, you can't push everything off to the end, sir. Eventually, later's going to come and you're going to have to deal with it. Abramson says, all right. The court says, all right, let's go ahead. I won. I'm the court, and I get to boss Ms. Abramson around. Ugh. Okay. The court says, "All right, the tape, Exhibit 52, has been played. Let's take a recess at this point, and we'll resume at a quarter after 11. Don't discuss the matter with anyone. Don't form any final opinions about it, and we'll resume at quarter after 11. I'll see counsel back here at 11." Following proceedings were held in court. So the court is back. The defendants are coming in regarding the request by the defense for a limiting instruction on the questions and statements in the audio tapes. I received the request of the defense, and I heard there was a concern by the prosecution regarding adoptive admissions. I'm going to suggest this as a resolution, adopting the defense language to the prosecution's concerns. Any statement, so this is what he's proposing that he read. Any statements by others referred to by the police in questions asked the defendant, and any questions asked a defendant are not evidence. Such statements and questions may only be considered as they enable you to understand the response of the defendant. But this doesn't cure like a bias that you might have that you don't even know you form because of the way in which the question was worded or the way in which the person asked the question. So if a detective is using the read technique, which I've talked about many times on this channel, which basically is a form of torture, so you're going to get a confession whether they're guilty or not, most likely. Um, The read technique is used by officers. They lie. They use their body language to intimidate, to make the person feel like they can't leave the room. They do a lot of different little techniques like that, and the way that they grill and question people, they're told that they should lie to get whatever confession they need, and it's pretty brutal. And that's just psychological. Imagine the officers that might rough them up a little bit too. I'm not saying that happens a lot, but I'm just saying it happens. So, um, just saying. All right. I don't know where I was going with that, but So, officers not being able to answer or not being able to ask these questions, where were you on the night of this when the Calabasas robberies happened and blah, blah, blah. Like that paints a picture in your mind you can't get rid of. So even though you're not supposed to use it as evidence or truth, your brain doesn't question it. You hear it and you're like, oh, okay, it's evidence. You don't think to like parse it out and be like, well, is that evidence? Is it true? Did the officer really hear that or see that or whatever? And a lot of times the answer is probably no. Anyways, Mr. Gessler says, I think that's fair, Your Honor. Mr. Khan says, yes, Your Honor. The court says, okay. The defendants entered the courtroom. The court says, all right, then I'll give that admonition, admonition to the jury. If you want to preserve that for the instruction later on, then I would suggest that counsel prepare such and make note of it for instructions later at the end of the case. All right, you had something, Miss Abramson? And she responds, there are two things, Your Honor, and this has to do with these tape transcripts and the difficulty that we're having. And we're at fault as well just because we're not able to stay up all night preparing and in not catching what's going on. What the prosecution is giving us at the last minute and shoving across the counsel table. And in the course she does not mince words, and I love it. I love that about her. Like, more people should just say it like it is. And in the course of listening to this tape, my client remembered better than I did that there was a similar dispute that last time the tape was played in the first trial, and that is that the people on their own at that time excised a passage in which Eric Menendez was talking about the charity work that he did. And the significance of that passage was not that he was talking about charity work, but because, based on our opinion and what we intend to prove, he was on the verge of confessing the crime to the police at that time. What I have here are there were two transcript segments, if you will, that were admitted into evidence at the first trial. One of them was Exhibit 129, and we had a whole flap about this then that the people had excised two other pages that we thought had to come in, and eventually they did come in as Exhibit 131. Now we're in a slightly different posture because the people are not seeking to prove up the Calabasas burglaries, which these two pages in part refer to, but we're in the same position vis-a-vis the significance of our client's state of mind when he made the statements that when I was young, this is what the crucial statement meant, or this is the most crucial statement. When I was young, I used to love everything. I couldn't break a branch of a tree, a leaf off a tree, or something. I used to love everything. I wouldn't want to hurt anything. And it seems as one gets older, they have to experience things and life is colder. Oh my God, that breaks my heart. Knowing that these boys were just like pure love and willing to like take on the world and just embrace it fully. And it was robbed from them. Totally robbed from them. And Jose and Kitty, it's your fault. All right. And both our expert witnesses and our client believe that that's a significant statement where just as when he talks about smelling smoke and seeing haze, he's dropping cues of his own guilt to the police. And Detective Zoeller would testify, if permitted, that he felt, based on his contacts with Eric Menendez, that Eric was on the verge of confessing to him and that if he had been able to interview him between the date September 17th and December when he tried to, that Eric would have confessed to him. So this was significant. It was in the record that there had been a dispute over the admission of that, and I frankly have failed because when I got this yesterday from the prosecution that the version they now wanted to use, I didn't scrutinize it carefully enough, and I I didn't scrutinize it carefully enough, and I didn't remember that previous controversy, and there it is. So, what we would like to do at this time, Your Honor, so we don't get into a whole long flap about it, is to be able to question on cross examination of Detective Zoeller that they also had a conversation about other things that were not directly related to his investigation. And when that, at one point, Erik Menendez was ruminating and made this statement. And eventually, what we'll do is there is another piece of the tape that was admitted in support of Transcript 131, which was Exhibit 130, and we'll provide that a redacted exhibit that captures those words, and we'll call Detective Zoeller and play them at the appropriate time, which will be as soon as we can, which will be as soon as we can do this and have the right to recall him for further cross and play that piece of tape. But this is the problem that keeps occurring because it was a very complicated first trial. There was a lot of dispute over many of these transcripts, and the prosecution seems to rely that they have a right, based on what Mr. Kuriyama told them, to pick a particular version. Now, and then the court cuts her off again. Well, wasn't there a hearing on the admissibility of these two tapes before this retrial? And wasn't there an exhibit presented to the court by the prosecution in support of that motion? Ms. Nahara says, Your Honor, court continues, and the court ruled, I don't have the exhibit in front of me, but we can certainly retrieve it. And whatever transcript was the subject of that hearing would be my belief is the transcript that was given to the jury here. Now, and Ms. Abramson now cuts him off. I can't verify it. The court says this is not something that just occurred yesterday or today, but that hearing occurred 6 or 8 months ago, and you had plenty of time before the hearing to review the entire transcript, so this is nothing new. Ms. Abramson said, You're talking about something that was filed a year ago and a half, Your Honor, in the proffer of evidence. The court says, well, the hearing was long before the beginning of this trial. He's such an ass. Breathe. Breathe, Ms. Abramson, breathe. I'm feeling for you. Ms. Abramson says the issue wasn't the subject matter of the hearing. The issue of redacting the transcript, or what the final version of the transcript wasn't the subject. My understanding, and I may have it wrong because, frankly, I wasn't dealing with that part of the case at the time, was that the entire tape, see, there was an original taped transcript that had every word that anyone said on it, and it was my understanding, and I may be wrong, that at the time of the proffer, the whole transcript is what was before us, and that the people hadn't made an election or a selection then whether they were or weren't going to get into Calabasas. The court says, wait. Whatever transcript was presented to the court for that hearing, it was the transcript that was in litigation and the one that the court ruled on. And at that time, there was some ruling made in redaction, certain things at the time we litigated that. Ms. Abramson says, but there was no, the court says, I'm just saying that because you're saying that this is all last minute sort of thing and just dumped on you, but I'm just saying that the transcript the people have produced here is identical to the transcript that was used for that motion. And if so, then Ms. Abramson cuts him off and says, I don't know, but that I have. The court says, you've had it for a long, long time. Ms. Abramson says, well, but we have that transcript across the street at the public defender's office, and I will bring it in this afternoon. I can't tell you that I remember now what was proffered in that transcript so many months before because there were many other evidentiary issues that the court was going to decide that then impact on what are the proper redactions for any one of those transcripts. Court says, my ruling was at the time it was admissible as to both defendants with the redaction of reference to Lyle Menendez purchasing the Rolex. Ms. Abramson says the issue there had to do with cross-admissibility, Your Honor, and not the specific redactions that the people have made in the last trial. The court says, all right, I just made that statement because it's clear that the tape issue was known to counsel long before now as to the specifics of what is and what is not in the transcript, that I agree wasn't subject to specific litigation. What is the people's response to this particular statement? Miss Abramson says, here are the two exhibits. And she hands, or I guess she was handing them to Ms. Nahara. Ms. Nahara says, Your Honor, on May 16th, 1994, we filed with the court and with counsel the people's proffer of evidence to be presented before a single jury. This was to be litigated on June 27th, 1994. It ended up that because of preparation and whatnot, it was litigated on April 3rd, 1995. So almost a month later, or almost a year later. Attached to that proffer as an exhibit, and it was, in fact, exhibit A of that proffer, was the interview of Erik Galen Menendez. It was the interview that the people proposed to enter into this trial. It is identical to the transcript that we have presented in court today, with the only difference being that on April 3rd, 1995, the court made certain rulings concerning redactions that this court wanted the people to do on this tape. Now we complied with those redactions. Counsel had this exhibit from May 16th, 1994 to now. On April 3rd, when we were discussing this and the court was making the rulings, defense counsel never suggested or stated in any way, shape, or form that they wanted to add more to this tape. This was the time when it would have been appropriate to do this. They have now put us in the position of sandbagging for 2 hearings for over a year and a half and now come forward and say, oh, we have decided we now want the tape to add this piece of these 2 pages that the people had never offered, rather than doing it ahead of time when we could have litigated this. We would have suggested that under 352 it should not come in, but the court could have made a ruling, and had the court ruled at that time then it went in, we would have been in the position to put it all before the jury. Because of their sandbagging and their inefficiency, they have put us in a position where it looks like now we have improperly redacted something when, in fact, that couldn't be further from the truth. We presented the defense over a year and a half ago what it was that we wanted or intended to proffer to the jury. We discussed it. They had it for since May 16th of 1994. This is October 12th or 13th. Sorry. The court says, okay, let me stop you there. The transcript is not before me. I don't have it. I have it in chambers, the one that was subject to this earlier hearing. Whether or not this particular portion was not in the transcript that we've been referring to regarding the people's proffer of evidence, I had no way of knowing at this point. However, the court ruled in the first trial that this particular portion would be admissible, and based upon the totality of the tape recording, that ruling would be the same now. And if it is to be brought out, it can be brought out by the prosecution in the completion of its direct evidence of Detective Zoeller or in cross-examination. If it's brought out in cross-examination, it should be clearly stated that in some fashion that this was done, at least the omission was not done by any side to mislead the jury or to conceal information. It was just information that has been separated out and will be considered for the jury in the totality of the recording, and it has no more significance than any other part of the recording. Ms. Nahara says the problem with that, Your Honor, is that it now looks, thanks to Ms. Abramson's objection, her speaking objection, that the people now who try to present this after the fact were trying to conceal something when all of this could have been avoided had they done their job and done the job back on April 3rd, 1995 when we had the hearing on the subject. So it puts us at an extreme disadvantage because we didn't know what they were going to offer, or that they were going to offer this. Now they came in at the 11th hour and offer this, and all of this should have been litigated in April. And it does put us in an unfair advantage, and I don't know why they didn't bring this up in April. Ms. Abramson says, "You know what the problem is. You think you have a right to rely on rulings that this court made in a previous trial unless and until someone brings to the court's attention a challenge to that ruling." Now, both of these transcripts were admitted. I mean, she has a great point. It's a totally different ballgame. It's a new trial, so you can't rely on previous rulings. Now, both of these transcripts were admitted in the previous trial, when the people that decide on their own to proffer less than what this court agreed was admissible, even in their proffer, they should have redlined and shown that we are now offering a different version that the court ruled was admissible in the first place. We want to relitigate the issue that the court ruled adversely to us on Exhibits 130 and 131, but they don't do that. The court says, okay, again, I've already given you my ruling, so what you're saying doesn't change anything. Ms. Abramson says, but there is this particular transcript now, 131, and the tape that accompanies it it is our position that it cannot simply go in now without further redaction, because in the middle of it, Detective Zoeller asks, how did it develop the charity work? Was it because of the Calabasas thing? And then Mr. Menendez says, it was because of the Calabasas thing. My lawyer suggested it. So that part still needs redacting. The court says, that's fine. You folks can work on that during the lunch hour. And the people, I assume you have more of Detective Zoeller before you finish. And Mr. Khan says yes. The court says you can decide as to how you want to bring it out. Let the defense do it or bring it out yourself as to whichever way you want to do it. Ms. Abramson says, and I'm willing to stipulate it was an inadvertent omission in front of the jury so that the prosecution so that there's nothing negative. It was an inadvertent omission from the tape. But we need to discuss before they get into, Your Honor, the other tape as well, the Ozeal tape. We simply don't feel it's appropriate for the jury to see what the Exhibit 322, nor for it to be entitled Menendez Confession. One thing that we all agree upon during the last trial was that 322 was not accurate, and so each side, the defense and the prosecution, offered that they believed to be an accurate transcript. One of us offered 326 and one of us offered 354. They were both called disputed. I don't specifically remember, but maybe the court does, whether or not the disputed transcripts, along with 322, the original version, went to the jury. But the court cuts her off. Well, I have the list of exhibits, the actual list that was given to the jurors, without reference to whether things were disputed or not. So I can tell you that the Erik Menendez jury, they received Exhibit 354, and the Lyle Menendez jury received 322. I don't see 326 being received by either jury. Ms. Abramson says 326 was listed as a question mark as to who offered it. The court says, yes, I'm saying I have the list that was actually given to the jury, which conforms with what they actually had. Ms. Abramson said, so the Erik Menendez jury only received 354, not 322. The court says, and the Lyle Menendez jury got 322. And the reason for the difference is that the jury was given the evidence first for Lyle Menendez because they argued first and they started their deliberations first. Ms. Abramson responds, then it sounds like 354 wound up being the official version at some point. The court says, well, at some, or at least by stipulation of the parties as to the Erik Menendez jury. Ms. Menendez says, well, it's our position, Your Honor, that 322 is not an accurate transcript, and I'd like just briefly to be able to review, 322 to 354 is that we understand was the final version because that's the one where I blew up the 2 pages, 27 and 28, for our exhibit because this is what was in our file as the final version that was given to the jury, and therefore it's our position that 322 is not accurate and that 355 is the version that should be given to the jury. Okay, my head's spinning with all of that. Court says, bear in mind, these transcripts are just given at this stage for the jurors to listen to and follow along as they listen to the tapes. Well, yeah, but you don't want to have it say inaccurate things or things that are supposed to be redacted. You don't want them to be on there and heard by the jury because you can't unring a bell. So it is kind of an issue, Judge. Ms. Abramson says, I know. The court says a refined version will go to the jury as an exhibit. So if you hear something, but you see it in writing as something else, you're going to believe your eyes over your ears, most likely, even though in this case you're supposed to listen to, or you're supposed to believe your ears over your eyes, because the judge specifically gives you that instruction when listening to a transcript or listening to an audio version and looking at the transcript. You're supposed to disregard the transcript, but most people are going to see what's on the page, and that's what's going to stick because most people are visual learners. So if it's wrong on the transcript, most likely that's the thing that's going to stick with them. So that's a big problem if you have inaccurate things or whatnot. So Ms. Abramson says, well, the problem with 322, though, in any event, it's appropriate because it has handwriting that might be in controversy, and it would not be appropriate for that person who put most of the handwriting notes to testify about whether it's accurate or not, because that's both myself and Miss Morrissey. That's whose handwriting is all over 322. The court says, well, we wouldn't have testimony about that, just that there happens to be handwriting on it. That's all. Ms. Abramson says that I understand, Your Honor, but 354 was something that the prosecution had input on and was the eventually stipulated to version, and we would simply add, and it doesn't have Menendez's confession. The court says, which version was it that the people wanted to use yesterday and you objected to? She says, another version altogether. The court says, you sure of that? She says, yes, it was a different typeface. It looked like that, and in my left hand is 354 and is a different version. The court says, what's your position regarding 354? Ms. Nahara says, we haven't seen 354. We're comfortable with 322. We've read it. We also made copies. For the time being, the court said we're just using this as a descriptive tool more than anything else. The court told us yesterday that 322 was the official transcript. That's the one we've been working on. If there were notes and things on the sides, like handwritten notes, and you're making copies of it for the jury and the handwriting's not supposed to come in, like, can't you block that, redact it? I don't understand why it was in there, but okay. The court says it was a transcript that went to one of the juries. Ms. Nahara says we're prepared to go forward. Ms. Abramson says it didn't go to the Erik Menendez jury. We had a more accurate one and we object to 322. It was not accurate. The court says, all right, okay, when are you going to be playing this tape? Mr. Khan says, right now. Okay. Ms. Nahara says right now. The court says, if you use 322, you'll have to redact from each of those any reference to confession. Ms. Nahara says, reference to what? The court says confession. It says confession on the face of it. She responds, can we have just 10 minutes to do the cover page? And Ms. Abramson says, why don't we have 10 minutes to run 354? She's not giving up on that. Ms. Nahara says, Your Honor, we only have to run one page. The court says, I understand what you're going to do. you're going to run one page. Mr. Levin says, what we're talking about, there's a major difference between 322 and 354, and one of them occurs on page 3. There's no line, but it's apparently LM, Lyle Menendez, talking about how he immediately encouraged his mother on the exhibit 322. It's the same passage, but instead of saying encouraged my mother, it says pushed my mother. And this is just on page 3. There are other substantial differences between 354 and 322. The court says, again, this is going to be subject to the same instruction I've given and will give the jury that this is only to aid in listening to the tape, and the evidence of the conversation is the tape, not the transcript. And before a transcript goes to the jury, it is final. In its final form, it will be subject to further litigation. As Ms. Abramson says, but impressions are made, Your Honor, as the evidence comes in. Exactly. She's right. I am with her on this. The court says, I'm going to let them use 322 because it was an exhibit that was used in the first trial, and it was found at that time sufficiently accurate for that purpose. Yes. Ms. Nahara says, Your Honor, do you want the date off of it? I'm sorry, I want to get this off of it. The court says, yes, the date should come off too. Mr. Gessler says, I join in the objection, Your Honor, that even though apparently the 322 was used in the Lyle Menendez jury the first time, we now have a better and more official version of 354, which we would also ask that be given. And on the grounds that people learn more by what they see than what they hear, that first impression of what they read is going to carry more with them than another version. That's just what I said. That they take into the jury room. You're going to take it with you, the transcript, what you see, with your eyes. You want to, like, people are, got to see it first, got to see it with my own eyes, and then I'll believe it. You're going to see it on the page, and then that's what you're going to take with you, not the audio version. The court says, considering the fact that they will have the tape recording itself and a final version of the transcript that will be one that is agreed upon by all parties, and the fact that this tape and transcript will only be given to the jury in their deliberations, which will be several months from now, the court finds that using the exhibit 322 at this stage just to assist in following along and listening to the tape is not prejudicial in any way. Wow. Not prejudicial in any way. Okay, Judge. Okay. I'm not even going to say that that would get him a new trial, because that obviously, like, something like that wouldn't get him a new trial, but there's got to be other errors here in these arguments that we can find that they should have been argued for their release sooner. Anyways, Mr. Gessler says, then could I ask that the court, in addition to telling them that it is just an aid to them, that it is in dispute and is not the final version? The court says, well, I'll say it's certainly not the final version and it is not accurate and there's going to be some modifications and changes. Mr. Gessler says, thank you. Ms. Abramson says, thank you, Your Honor. Ms. Nahara says, one last point. Oh, come on. We were so close to getting the jury in. Ms. Nahara. Counsel suggested that the court tell the jury that the people had not or had made an inadvertent omission or language to that effect, and our position is that we haven't done anything inadvertent. The court says it's not the people, it's the parties. Both parties have done this. It's not one side or the other, it's just both sides by just omission. Ms. Abramson says the stipulation was going to be that that a part was inadvertently omitted. I can't talk. Hold on, I need water. All right. Ms. Nahara says, my concern is Ms. Abramson before the break said that the people had improperly redacted something Now we're going to play something that's clearly out from the tape, and it's going to look like we've been told something was wrong and now we corrected it, and I would like that to be cleared up. The court says it will be cleared up. No one was at fault for this. Nothing was done improperly. Okay, are we ready now for the jury? Let's get the jury out. The judge is not having it today. All right, so Ms. Nahara says they're doing the new front page. The court says, is that the exact next thing you're doing? Mr. Khan says, I can move on to something else. The court says, okay, let's get the jury out. The jury enters. Court says, all right, the jury is back in court in relationship to the two tape recordings that you heard and you might hear more of. The two tape recordings made on September the 17th in New Jersey, one involving an interview of Lyle Menendez and one involving the interview of Erik Menendez by Detective Zoeller and his partner. Let me say this. Any statements made by other people referred to by the police in their questions are hearsay and are not evidence. So if the cops say, well, so and so said you did it, so and so said that so and so, that you told so and so that you did the crime. That's all hearsay and it's not admissible, or it's not offered for the truth, is what they're saying. And also, any of the questions asked by the police are not evidence. Such statements and such questions may only be considered as they enable you to understand the response to the defendants to the question or statements. All right, people may proceed. Mr. Khan. Yes, Your Honor, I have another photograph in my hand, which I discussed with counsel this morning. This photograph has not been previously marked. May this photograph, which depicts a portion of a bracelet on a sofa, be marked as People's 54 for identification? Court agrees. Mr. Khan continues his questioning. Detective Zoeller, yesterday I was questioning you about the various numbered items, that is, property items, that were identified in the den of, that is, the crime scene. And I questioned you in regard to the item number 5. Let me show you the photograph that has just been marked as People's 54 for identification. Can you tell me, or tell us, what that photograph is? Ms. Abramson says, can I confer with counsel for a minute? The court says, sure. All right, Mr. Khan continues. Do you recognize what is depicted in that photograph? Yes, I do. And can you tell us what that is? Item number 5, for the item number 5 listed in the photograph, evidence number 5, a piece of a white bracelet and a shotgun wad, which you can see right below it. I have another photograph in my hand which has not been previously marked. I'll mark this People's 55 for identification. Showing you People's 55, can you tell us what it is that is depicted in this photograph? Yes, this is the photograph of the stain in the kitchen that was labeled number 24 on the chart. 23? I think it was 23. 23. Ms. Abramson said 23, question mark, and Mr. Khan says, I think it was 23. The witness says correct. It's a picture just depicting the stain on the floor, Mr. Khan says. And how far into the kitchen, walking from the den, did you observe the stain that is depicted in the photograph number 55? The flooring in the photograph, I believe, starts a little bit before the kitchen in that hallway and was approximately 2 feet towards the kitchen on that floor. And were you able to take any other photographs which would depict that stain from a distance so that you would be able to see how far into the kitchen that stain appeared? No. I would like to move forward for the moment until sometime after the arrest of the defendants in the case and direct your attention to the date of March the 14th of 1990. Now, at that time, do you recall going down to San Diego? Yes. What was your reason for going to San Diego? There were actually four of us investigators that went down there, And our purpose was to check gun stores, in particular gun records of those stores, for purchases of shotguns. Your Honor, at this time I have an exhibit that was used in opening statement which has not been marked. It is a map of the Southern California area. May this map be marked as People's 56 for identification? The court says yes. Now, prior to going down to San Diego, did you conduct a search of gun stores in the Los Angeles area? Yes, I did. And can you tell us approximately how many gun stores you searched in the area? I believe it's in the area of 100 gun stores. That's a lot. And what were you looking for at that time? I was looking for purchases of shotguns by any individual's name that I recognized. In particular, I was looking for the Menendez name. Okay, and in order to conduct that search, do you look through a particular type of record? Yes, the ATF records. Can you tell us what an ATF record is? It's the Alcohol, Tobacco, and Firearms Record. It's a government form that is required for each weapon purchase. All right. So then on on March the 14th of 1990, can you tell us where specifically in the area of San Diego you went? We'd been checking the big five stores, and they had 5 or 6 big five stores. And the last big five store that we checked, which was on Convoy in San Diego, we checked that one last. Uh, we checked that one last and found the records that we felt would be beneficial. Okay, directing your attention now to the map that has been marked as People's 56 for identification, can you tell us what that map depicts? It's a map of the Southern California area from Los Angeles to San Diego. The areas depict the area of Beverly Hills and the area of San Diego. He says area a lot. And do you see the two specific locations that are highlighted on the map? Yes. The top photo by Beverly Hills is the Beverly Hills home of the Menendez family. The bottom photo, which is the Big Five store that was searched in San Diego. Okay, can you tell us what the distance is between the Beverly Hills home of the defendants in the case of the Big Five store that you went to in San Diego that day? It's approximately 100 miles. All right. At this time, Your Honor, I have some documents contained inside an evidence envelope. This was previously marked as Exhibit 52 in the first trial. May this be marked as 57. The court says yes. Mr. Khan continues. Showing you People's 57 at this time, I would like you to open up and remove the documents that are contained within that envelope. Detective Zoeller says, I'm taking out 3 pages of a notebook. The first page, which is yellow, was actually the book that I was looking through, their ATF book, which shows the purchase of two Mossberg shotguns on August 18th, 1989, to a Donovan J. Goodrow with a San Diego address. And before we go any further, in regard to that particular document, can you tell us if you recognize the other documents that were contained inside the envelope? Detective Zoller says, yes, I do. These were documents more on the stock control documents from the store. All right. And one for each weapon. Mr. Khan says, all right. At this time, I have a blow up of those documents. This is an exhibit that was previously marked 53B. May this exhibit be marked as People's 58 for identification? The court says yes. I would like you to just, if you would, first just flip through the pages of this document that blow up and tell us if you recognize what is depicted on each of the pages in that exhibit. Detective Zoller says, yes, I do. And can you tell us what this exhibit consists of? He says the first page of the exhibit is the front side of the yellow page. Page 2 is the back side of the yellow page. Page 3 is the page that indicates page 29 on it. What? That's confusing. And the last page, page 4 of the exhibit, is the page that says 36 on it. All right. Thank you. I'll put the exhibit up on the board so everyone can see it. All right. There appears to be in the upper left-hand section of the document the name that appears to be Donovan Goudreau. Is that the name that you were referring to when you said that you recognize that particular document that is in front of you? Yes. And can you tell us why you recognize that name? In the course of the investigation into this crime, I received a phone call from a Donovan J. Goudreau who indicated that he was Ms. Abramson objects hearsay. Mr. Gessler also objects hearsay, and it was sustained. That's pretty great that they both objected at the same time. And it should have been sustained. All right, so Mr. Khan says, well, we're offering it not for the truth of the matter, but just for the purpose of identifying and seizing the document. Court says, well, the fact that he recognized the name is all that would be relevant at this point. Mr. Khan says, all right, after you recognized that name, what did you do in regard to that particular document? I seized it as evidence. And in addition to that one particular document in other on which the name Donovan Goudreau appears, did you also take those related documents which you now have before you and which are marked collectively as People's 57 for identification? Yes. All right. And once again, I want to go back in time now prior to the time that you conducted that search in San Diego to about 6 days earlier. Do you recall obtaining a search warrant on or about March the 8th of 1980? Yes. And where did you go with that search warrant? I went to Dr. Oziel's residence, which was at 3744 Long Ridge in Studio City. And at that location, did you meet Dr. Oziel? I want to Google that and like Google Earth it and see where he lived because Dr. Oziel's a little wacko to me and it'd be interesting to Google Earth his house. I'm not stalking him. Don't worry about that. All right. And at the location, did you meet Dr. Oziel? I'm sure he doesn't live there anymore. Eventually, yes. And that's what date was that? That was on March the 8th of 1989. Okay. And after you met Dr. Oziel, did you provide him with a copy of the search warrant? Yes, I did. And after you provided him with a copy of the search warrant, did you go with him somewhere? Yes. Where did you go with him? I went to his personal bank, which was the Federal Savings Bank at 13330 Ventura Boulevard in Studio City. And when you went to that bank, who were you with? I was with Dr. Oziel, his wife Laura or Laurel, a Mr. Mogul, Identification Bureau technicians Kurt Kuhn and Jim Wagenbrenner, Detective Linehan. I believe that's all that was there at the time. Okay, Detective Linehan, you said is a detective with the Beverly Hills Police Department? Correct. Kuhn and Wagenberger, who are they? There are identification technicians for the city of Beverly Hills. Okay, and Mr. Mogul, who is he? He's a special master. Can you tell us what a special master is? A special master is required by law when evidence is being seized or a search warrant is being served on a clergy, a doctor, an attorney. Okay. And after you got to the bank, can you tell us what happened at that time? When we got to the bank, Mr. and Mrs. Oziel and Mr. Mogul went into the safety deposit box. Ms. Abramson says, I'm going to object to that, Your Honor, unless there's a showing of personal knowledge. The court says, sustained. The answer is stricken. Oh, so we got 2 sustains in a row. Nice. The jury is ordered to disregard it. Mr. Khan continues, tell us just what you saw Dr. Oziel do at this time. I saw them go into the area where the safety deposit boxes were. Within a few minutes, I saw them come out with tapes. Okay, and were those three people who went there together? Yes. And can you tell us what the role of the special master is in regard to a search such as that? Your Honor, I'm going to object as irrelevant. The court says it is irrelevant in general. What happened here is the issue. How long were they gone out of your view? That is, Dr. Oziel, his wife, and the special master. It seemed no more than just a few minutes, 5, 10 at the most. And when they came back, was some item given to you? No. Okay, at some point did you see a tape recording? Yes. Can you tell us where you were when you first saw that tape recording? I was at the bank outside the safety deposit box area. And which person, if any, had those tape recordings when you first saw the tape recordings? I'm not positive, but I remember at that point, Mr. Mogul had possession of the tapes. Okay, and were there tapes in some sort of a container? I don't believe so. No. Your Honor, at this time, I have a tape recording which has previously been marked as 322 in the first trial. May this be marked as People's 59 for identification in this trial? Court says yes. Directing your attention to what has been marked as People's 59 for identification, can you tell us if you recognize that tape recording that I just handed you? Yes. Can you tell us what that is? It's an audio cassette tape with writings on it and a date. And have you previously seen that tape recording before? Yes. And where was it that you first saw that? I first saw it at the bank, and I subsequently saw it in the first trial. Whoops, sorry. I subsequently saw it in the first trial of this case. Okay, now this is the tape recording in the original tape recording that you observed that day. Is it not a copy? That's correct. Ms. Amerson says, objection, Your Honor, ambiguous. Objection, Your Honor, conclusion. They didn't answer the question. The court says, the question is the same tape recording he saw at the time he saw a tape recording in the bank. Is that your question? Yes. Or one of the same? Ms. Abramson says. The court says he's asking if it's the same item. Is that your answer? The witness says it is. The court says objection overruled. Mr. Khan says, and at some point, did you take possession of this tape recording? No, I never took possession of it. Okay, did you have a role in the transmission or delivery of this tape recording to some place? I don't believe I did, no. So a weird way to answer that, like either yes or no. Okay, and have you listened to this tape recording during the time of the first trial? Yes. And do you recognize the voices that are contained on this tape recording? Yes, I do. And have you listened to the entire tape recording? Yes. Can you tell us whose voice appears on this, or whose voices appear on this tape? The voices are Erik Menendez, Lyle Menendez, and Dr. Jerry Oziel. And you know the voice of Erik Menendez from the occasions that you spoke to him? That's correct. Prior to his arrest in March of 1990, can you tell us on how many occasions you spoke to Erik Menendez? How many times? Approximately 5 times. And prior to his arrest in March of 1990, can you tell us how many times you spoke to Lyle Menendez? 4 or 5 times also. And how many times have you spoken to Dr. Oziel? Numerous times. Mr. Khan says, now I'd like to mark this at this time a transcript that was previously marked as Exhibit 322 in the first trial. May that be marked as Exhibit 60 in this trial? The court says yes. Showing you Exhibit 60 at this time, do you recognize what is being shown to you? Yes, I do. And can you tell us what that is that you have before you? It's a transcript of the tape that I previously described. And once again, is there a legend that identifies the speakers in this recording? Yes. Ms. Abramson says, Your Honor, I would object to his reading anything from the transcript for a hearsay purpose. That transcript, court says, overruled, overruled. So again, like, cuts her off, doesn't listen to her argument. Shut up, woman. You make my life miserable because you talk too much. Sit down. I mean, that's kind of how I feel about him. I don't have really high hopes for him. Sorry. In this trial, anyways. It's not going so well. Mr. Khan says, and can you tell us what is the marking in this particular transcript which identifies the different speakers? Joe is Jerome Oziel. LM is Lyle Menendez, and EM is Erik Menendez. I think most people could probably figure that out on their own, but good to tell them. Your Honor, at this time, I would ask that the bailiff collect the last set of transcripts and distribute a new set of transcripts to the jury. Court says, all right. Mr. Gessler says, I'll object, Your Honor, to the transcripts and to the tape for lack of foundation. I would like to be heard. The court says, all right, we'll have transcripts picked up. And since it's 7 minutes to 12, before we get further along, we'll take our recess for the lunch and I'll talk to the lawyers and have you return at 1:30. Ladies and gentlemen, don't discuss the case with anyone. Don't form any final opinions. So Leslie's already asked to be heard multiple times, and I know he's turned her down multiple times, or at least once. I can't remember if he brought her up or allowed her up. I think he might have. But anyways, the point is, Leslie asks, Your Honor, I'd like to be heard. He's like, okay. This guy says, Your Honor, I'd like to be heard, and uh, Judge Weisberg is like, sure, let's break jury out. But Leslie asks, Your Honor, I'd like to be heard, and it's often a no, or you have my answer type of answer, and we're continuing on. He'll just ignore her. Like he won't answer her request. He'll just be like, no, we're going to continue. So there's a huge discrepancy to me in the way that he treats Leslie Abramson versus the men. Just saying. Just a noticeable difference. All right, so the jury exited the courtroom and the following proceedings were held. The court says, yes. Mr. Gessler says, Your Honor, I'm objecting on all grounds previously stated as to the foundation and lack of authentication for this tape that has been marked Exhibit 59 and the derivative of it in the transcript that is now marked 60. In addition to all grounds that had been previously noticed, that is, that there is no beginning to this tape, no ending to the tape, there is a click on the tape that comes up in about the first 30 seconds of it that is unexplained because Detective Zoeller was not present, but by his own admission for any part of the tape being made. And the bailiff says, Can I interrupt so I can get the jurors out? Court says, sure, please. And there was a pause in the proceedings. Bailiff says, okay, that's all. Court says, okay, you may continue. So they must have been arguing while the jurors were still leaving the courtroom. In addition, Your Honor, I believe there's been previous testimony by Detective Zoeller that he was not present, and I don't believe that he said either Oziel or Mogul went into the room. But the biggest problem is chain of evidence. Here, what we have is Detective Zoeller saying he recognizes an audio cassette tape being Exhibit 59 as at least one that he had seen at the bank and at the first trial that he'd seen at the bank. He says he never took possession of it. Oh, at the bank to get it at the direct deposit box, sorry. He said he never took possession of it, had no part in transporting any of the tapes that were recovered from the bank to the court. the police department, or any place else, as far as we know. There's nothing he said he that he marked that particular tape or any type or any tape. Oh my God, I cannot read. Or any tape that came out from the bank with Mr. Mogul. In other words, no initials on it, no numbering on it, nothing by which he can authenticate the tape that he was later seen. Even if it was played in trial one, was the tape or any of the tapes that he saw brought out from the safety deposit box. So I think we have an additional problem now, in addition to all those that we raised earlier as to the authenticity of the tapes. So that's a good argument. Court says, all right. Miss Abramson says, it goes beyond that, Your Honor, just so the court knows. There's a record of this prior at the 1538 and a half motion or whatever that was made. Detective Zoeller testified on 5/13/93 that at pages 24-27 that at the bank, Dr. Oziel did not go into the booth where the safety deposit box was opened. Only Mrs. Oziel went and Gary Mogul and the bank person. So there's the problem that even the person who purports to know the content of the tape in turning over to the doctor in bringing it out wasn't even there. And then the other thing was that the court may recall during the motion that we had concerning keeping the tape out on 4/26/95 in volume 177. In the course of that hearing, Detective Zoeller testified that there were more than one copy of the tape dated 12/11, and I don't believe an adequate foundation's been laid to show which copy this is or whether this is just an original. So I join in the objection and add those points. The court says people wish to be heard. Mr. Khan says yes. Detective Zoeller testified that this is the original recording that he received that day. Ms. Abramson says he didn't. Mr. Khan says, and the court has previously ruled that the foundation presented by the people in the hearing that was held in the court was sufficient to establish the authentication of this particular piece of evidence. I don't know why I can't say that word today. So I would submit that we have demonstrated that the evidence is, in fact, admissible through the testimony of Detective Zoeller. The court says, all right, did you intend to call Mr. Mogul at some point during the proceedings? Mr. Khan says, yes, I could also call him. I think it's sufficient with Detective Zoeller. So I don't know if they do call Mr. Mogul. We'll have to look through that. I'm not sure. Because there's a lot of new names, but I don't remember seeing that one. But they might bring a new. They didn't. They're only in the first trial. The state's only real like experty witness was this guy, Detective Zoeller, and basically he's testifying to the scene of the crime, but not like the ulterior motive as to why did they do this, and was there some reason like self-defense behind it. So I guess they didn't really need too many people to talk on that because they didn't want us to think that it was self-defense. All right, so Mr. Khan says, yes, I could also call him. The court says, all right, the court did rule on the nature of the objections on grounds of lack of authentication. And I've heard the new objections stated today. They don't materially alter the facts as presented to the court at this time. Of course, they don't, of the hearing of authentication. And the court is satisfied that the ruling I made at that time that the people have met their burden to authenticate the tape was a correct ruling, and all the reasons stated for that ruling at that time remain valid reasons for the court overruling the objection. Mr. Gessler says, I would just state, Your Honor, that the last hearing that we had went to authentication of the tape itself and the four corners of the tape and did not go to the objections I've raised today as to authentication of it being the same tape and change of possession. The court says, okay, I understand that, but I think the people have, by the testimony of Detective Zoeller today, satisfied the court that there's sufficient evidence in the record to authenticate the tape and overrule your objection. It's like both sides are objecting and they both have valid reasons, and the court's just like, forget about it. It's all coming in. Mr. Gessler says, then I would just add one objection to Exhibit 60, Your Honor. There's been no testimony by Detective Zoeller that he has compared the tape itself, Exhibit 59, with the transcript that has now been offered by the people as Exhibit 60. He has identified the voices, but not the authenticity of that transcript. The court says, okay, well, the tape is yet to be played and the transcript has yet to be further reviewed by Detective Zoeller. I'm sure that can be asked of him before it is played. And of course, as I indicated, I'll make the same admonition to the jury as I indicated I would regarding the frailties of the transcript. Mr. Gessler says, finally, Your Honor. Then Miss Abrams says, speaking of which, and she was the louder voice because she got to speak. She says, speaking of which, we're now asking, since nothing's being given to the jury yet, that the more accurate transcript that was given to the Erik Menendez jury be the one, and we'll make copies of it over the lunch hour. The court says, I have no problem with any particular transcript going to the jury as long as there's no dispute about it. If there's a dispute, then I don't have time and I don't intend to resolve any disputes now and interrupt the flow of the proceedings. Rawr, I'm a big, angry, grumpy man. Ms. Abramson says, well, the only dispute is that 354 is the only copy of the transcript that was ever given to the Erik Menendez jury. Court says, I don't know that the dispute is with the prosecution. Ms. Abramson says, I don't either. The court says they have to speak for themselves. If there's a dispute, I'm not going to resolve it while the jury is here. They're here for testimony, and these are the types of issues that everyone knew full well that this tape was going to be played and that the transcript would need to be provided to the jury. And regardless of the level of cooperation between the sides, there should have been a great effort made to resolve any such disputes before now. And as I said, I'm not going to interrupt the flow of the trial by resolving disputes now. Abramson says, but Judge, we did rely that they had a relay that they had, no, rely, it's spelled rely. We did rely that they would at least use the one that had been accepted by the court and given to the jury, the one that I relied on. Oh, okay, so it was the word rely. Okay. In fact, the fact that they can come up with a brand new version and handed it over to us in the middle of court this week, I mean, they won't tell us that they're changing or what they want to change. The court says, with the understanding and the fact that there were two different transcripts given to the juries in the first trial. Ms. Abramson says, not my jury. The court says, listen, it wasn't your jury. It wasn't Erik Menendez's jury. It was the jury that was deciding the case, the people versus Menendez. And that jury got one transcript and the other jury got another transcript. And you should have realized there was that the possibility that there would be a dispute as to which transcript went to the jury. What a dick. I'm sorry, but he is. Ms. Abramson says, but they offered a third version, Your Honor. The court says, I'm not going to get into any further disputes. I've told you, if there's failure to resolve the dispute or disagreement between the parties, then the first transcript the people are proposing is the one that will be used for the purpose of playing, with the understanding that later on a more refined version will be given to the jury as an exhibit. Ms. Abramson says it's not the one that they were proposing. It's the one, and the court says, I'm not going to get into any further dispute. Hello? Like, it needs to be resolved, Judge. You just like to throw things off till later. Ms. Abramson says, we would ask that both transcripts be given to the jury. It's ridiculous to give them something we all know is inaccurate. It's crazy. The court says that objection, whatever legal grounds it has, is overruled. So that was like a total jab at her because calling something crazy isn't isn't a legal ground. So I get like they're getting real frustrated with each other. This is day 3. I can't even imagine what the pretrial hearings were like. We don't get to see them either. But leading up to this trial, it probably wasn't a lot of fun. Right, Ms. Abramson objection or says objection on the grounds that the court says, okay, we'll be in recess until 1:30. He just cut her off. Wow. And then Ms. Nahara says, actually, we had one last request if you could, court, and then, or if the court would, and the court says, what's that? So he won't listen. He won't let Leslie make her record, and he cuts her off. But Ms. Nahara's like, oh, actually, Judge, one more thing. He's like, sure. What is it? Wow. She says, we're willing to redact over the lunch hour the Eric Menendez little section, which I believe counsel wanted 20 to 24. What we'd ask is that the court redact that and that redaction because we have an objection to it going in because it misleads the jury as to why he's doing this charity work. And when the court first ruled that it came in, it didn't mislead the jury. It was relevant in terms of it. Taken in the totality, there wasn't that problem. There is now. So we'd ask the court to review that over the lunch hour and determine if the ruling's going to stand. Court says, I have nothing to review unless you give me something. Ms. Nahara says, that's what I wanted, to give a copy to the court and ask you to do that. Court says, okay, we'll be in recess until 1:30. A female media person now says, Your Honor, may I make a request for the media? Is it possible that we could get copies of the transcripts? The court says, no, these exhibits are exhibits in court custody and they're not being distributed. The media person says, they were distributed in the first trial, Your Honor. The court says, they're not. We're not distributing exhibits. Their exhibits were received in evidence. That's where they'll stay. Media person says, is it possible to get them from the prosecution with their permission if they're willing to make a copy? The court says, I'm not going to get into discourse right now with anybody. The parties before the court are the lawyers, not people in the audience. Wow. Somebody didn't eat their Wheaties that morning and they were pretty cranky to even like some random media person. Mr. Gessler says, we'll object, Your Honor, to the prosecution providing to the media any of the copies since the court has admitted that they are in dispute and that the record on the tape itself is the thing that the jury will listen to. Ms. Abramson says, and of course, we object to them giving copies of the tape to the media. The court says, okay, we're going to be in recess. I don't expect the parties to be giving exhibits to anybody. Ms. Abramson says, thank you. Gessler says, or copies of exhibits. Ms. Abramson says that's what he means. And scene. So then that's going to take us to our lunch hour. I'm going to read a little bit more. Might as well, right? All right, so now we are in the afternoon session. The court says the defendants are in court with their lawyers. People are here. Anything before we resume? All right, let's get the jury out. Ms. Nahara says, did Your Honor have a chance to review those documents? He says no. Mr. Khan says, Detective Zoeller. The court says, wait, we're missing a juror. Okay, the juror is back. You may resume your examination of the witness. He didn't even remind him he's under oath. But cool. All right, so you can lie right now. Direct examination is continued. All right, so before we get on to the next transcript and tape reading, let me ask you a question concerning the last transcript and tape reading that we have just reviewed with you, and that is the one relating to Erik Menendez. Now, you testified that that is an accurate transcript of the conversation that you had with Erik Menendez. Is that correct? That's correct. Now, is that transcript a complete transcript of every word of conversation you had with the defendant? No, it's not. Mr. Khan says, at this time, Your Honor, I would ask that the new transcripts be distributed to the jury for purposes of playing the tape. Ms. Abrams says, before that happens, Your Honor, I'd certainly like to see a copy. The court says, yes, we're referring now to the tape that Detective Zoeller testified about in relationship to the safety deposit box. Mr. Khan says, correct, Your Honor. The court says, now we're talking about this is now Exhibit 59 and the tape is Exhibit 59. The transcript is 60. Do you have that transcript? Ms. Abramson says, yes, it was just handed to me. The court says, did you want to distribute that to the jurors? Mr. Khan says, yes, Your Honor. The court says, let's do that. Somebody, the bailiff says, do we have transcripts? And then they are passed out to the jury. The court says, all right, ladies and gentlemen, again, you've been given the transcripts. The transcripts, whether it's this one or these others that you were previously given to repeat what I said yesterday, are just given to you to assist you in following along as you listen to the tape recording. The tape recording is the best evidence of the conversation, not a transcript, which is just somebody's interpretation of the words that are on the tape. And as you can see by the particular transcript that was just handed to you, Exhibit 60, there are numerous handwritten corrections on it. It's my information that even with these handwritten notations of the transcript, that the transcript is not 100% accurate. There are some things left out, some things in the transcript that are not completely in conformity with the words on the tape. Before the trial is completed, a more accurate transcript will be prepared. So don't use this transcript, even though you're using it now, with any other thought in mind other than to assist you in listening to the tape. Don't accept this transcript as a conversation or evidence of the conversation. The tape is that. And only use the transcript to assist you in following along as you listen to the tape. If you don't want to look at the transcript at all, you don't have to do it, or you don't have to look at it. You can certainly just listen to the tape and words spoken on the tape by themselves. All right, you may proceed, Mr. Khan says. Yes. And directing your attention to the transcript, which we have now marked as People 60 for identification, have you reviewed that transcript in the past? Yes. What does that appear to be an accurate transcript? Ms. Abramson objects. She objects given what the court just said. I'm going to object. The court says it's not 100% accurate, and we've already said that already. It's an effort to transcribe the tape as best could be done at this point. Mr. Khan says, all right, thank you. At this time, Your Honor, I would ask that we play the tape recording for the jury. I would stipulate once again that the court reporter need not transcribe the recording. Mr. Levin, so stipulated. And the court says, go ahead. And then Exhibit 59 was played. Sorry. The court says, all right, Exhibit 59 has been played. Mr. Khan says, after you recovered the recording that has been marked as People's 59 for identification, did you arrest Lyle Menendez? I didn't personally arrest him, but yes, he was arrested at that time. And how long after you recovered this recording was Lyle Menendez arrested? Within 2 hours. And where was Lyle Menendez arrested? He was arrested coming out of his home at 722 North Elm, Beverly Hills. And do you know where Erik Menendez was at the time? He was at a tennis tournament in Israel. And what action did you take, if any, to arrange for the arrest of Erik Menendez? Initially, I had tried to go through Interpol and through international channels to try to find Erik and have him arrested, and then through family members and an attorney. It was agreed upon that Erik would surrender himself coming back from Israel. It's not like he wasn't coming back, he was on a tennis tour. You don't have to like get everybody and all the feds after him, you know? He was coming back. Guys knew his flight when he was coming. You could have arrested him then, but he came back early, I believe. So, how long after March the 8th of 1990 did he surrender himself? He surrendered himself in the early morning hours of March 11th. 3 days after you recovered this tape? That's correct. And did he surrender himself in Los Angeles? That's correct. Thank you. I have no further questions. Yes. Okay, so this was direct examination, Detective Leslie Zoeller. And we're going to go into cross-examination. So, but it looks like we'll resume at 20 minutes after 3. The court says we'll take a recess, we'll resume 20 minutes after 3, 10 minutes after 3, 20-minute recess. Okay, don't discuss the case with anyone and don't form any final opinions. And then the court says, all right, we're ready to resume. We'll have the jury out. Who's going to start up here? You? Miss Abramson says, no, Your Honor, Mr. Gessler is going to start. All right, so Lyle's side is going first. I mean, Lyle and Erik are kind of on the same side, but they have separate lawyers. So Lyle's attorneys are going first. So the court says the jury is back. We'll now have cross-examination of Detective Zoeller by Mr. Gessler. Mr. Gessler says, thank you, Your Honor. Detective Zoeller, taking you back to this statement that you received from Joseph Lyle Menendez on September 17th, 1989. Do you recall your testimony on that? Yes. Now, you were talking to other relatives and he drove up? That's correct. You had no prearranged appointment with him at all? That's correct. Do you remember what time of day this was? Approximately o'clock. It's not, o'clock is not a time. I think the transcriber messed up there. And when he came in, he had a friend with him? Yes. Where did the friend go? The friend went, I assume, to the kitchen or to the back of the house. He did not go upstairs. Was it at that point that you asked Lyle Menendez if he was willing to talk with you? As he came in, yes. And what did he say? He had no objections. Where did you talk to him? Where? Where in the house? The living room, which is in the front of the house. And did he just come in, sit down, and talk with you? Pretty much so. He had no objection to it. In other words, that's correct. He just, as soon as possible, he sat down and you had the conversation that you related here. Yes. With the tape recorder out in plain sight, that's correct. And you made it clear to him that it was being tape recorded, in other words? Yes. Now, do you have a copy of that conversation with you, the tape recording part that you referred to, the transcript that was talked about that morning? No. May I have a copy of that? May I approach the witness, Your Honor? The court says yes. Mr. Gessler says, showing you what's just been handed me by the district attorney. Does that appear to be the transcript of the tape recording that you talked about this morning? Yes. And could you turn to page 30 of that, please? I'm at 30. Yeah, 30 at the upper right-hand corner there. I'm at 30. I'm sorry, I'm there. And about a third of the way down, there's a statement on the transcript by the Z. That's you for Zoeller, right? That's correct. It says in the transcript, now your dad seemed to like older women. Your dad seemed to think that they were dot dot dot. Is that what you really said? I don't believe so, no. Did he say Actually, what do you remember he did say, or did you say? Without repeating the exact words, something like, your dad didn't like you seeing older women. So, in the respect then, as far as you can see, the transcript is not accurate as to what your recollection is as to what was actually said. That's correct. And when you were talking about your father, your dad seems not to like your old seems not to like you with older women, were you talking about Christy and Charlene and Jamie, some of the girlfriends that you knew Lyle had? Christy and Jamie were more so than Charlene. I think she was pretty much the same age as Lyle. And then there are some other parts on that page that appear to be unintelligible concerning his relationships with those young women, isn't there? Yes. In fact, there's about 4 or 5 just in the next paragraph alone that are unintelligible. Yes. But the gist of that conversation was that he had brought gifts for these young ladies, wasn't it? That's the essence of what he was saying. I'm reading. Let me just. Sure. Reading. I don't make that same conclusion on that statement by Lyle. All right. Was there a line there where what is not unintelligible said we had problems there, that I would be too free with these girls and I brought them things unintelligible, so dot 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 dot. Do you see that on there? Yes. And then did you ask how did you pay for these things for these girls? Correct. That part of the conversation was about Lyle buying gifts for young ladies, wasn't it? And that end portion of that, yes. And then you said, did you get an allowance? And he says, not really. Our family had a lot of money, and so my dad was very free with Eric and I. Correct. So, right there in the police, the very first interview he does with Lyle, he's not, like, he has no concerns about money. It's more Zoeller that's concerned about the money. All right, so correct. And then there was a conversation about your dad thinking women were sort of bimbos and what he should do is date 'em, marry 'em on the weekend, but not spend money on 'em? Basically, yes. Ugh, he sounds like such a dream boat, don't you think, ladies, when all of you want to be with Jose? Ew, I can't even finish that sentence. Um, I can't, yeah, coming from Jose, that's his motto. Women are bimbos. You should date 'em, marry 'em on the weekend, and then not spend money on 'em. That's what Jose thinks of us ladies. So I like him even less. All right. Didn't think that was possible. Nah, it really does. I really have no high regard for him whatsoever. Now going to page 1 of the conversation again. Oh, about midway through the page, there's a number of unintelligibles, aren't there? Yes. But what you were talking about as you started the conversation was what Lyle was going to do with himself, where he was going to live, work. Is that correct? Yes. And it turned out, as you did that, that he kind of wasn't sure. He had friends in the Princeton area, but he also had business affairs. He had to see lawyers, so he might be going back to the West Coast. I mentioned the West Coast. He agreed with it somewhat. You said, I understand you might be going to the West Coast. He said, yeah, we'll probably be going out there. You know, we still got the house to straighten out and all kinds of things. Correct. Again, in essence, that part of the conversation was Lyle Menendez was not sure whether he'd be staying there in the Princeton area or coming out to the West Coast or kind of commuting between the two. That's correct. Then, turning to the area around page 19, that's the portion when Lyle Menendez was expressing some concern about the reports concerning organized crime or the mafia or something like that having to do with these homicides, isn't it? Yes. And you were assuring him that this did come from the Beverly Hills Police Department. That's correct. So you told him actually that it came from the coroner the best you could tell? That's correct. Was that true? I don't know. Well, was the Beverly Hills Police Department putting these reports out? No. And to the best of your knowledge, was it coming from the coroner's office? I don't know whether it was coming from the coroner's office or just a statement by the newspaper people themselves. The newspaper people. Did you tell Lyle Menendez that you were taking steps to kind of put a lid on the coroner's office and had, in fact, written a letter to Dr. Kornblum, to the actual head of that department? Yes, my chief wrote that letter. Was that true? Yes, it was. Was that because you felt that the coroner might well be where this information was coming from? Might well be where. Oh, that the coroner was where this information might be coming from. The essence of writing the letter to the coroner's office was releasing too much information about the evidence or the crime scene itself. It didn't have anything to do with releasing anything about organized crime. Did you tell Lyle Menendez that the media was talking a lot of these stories or taking a lot of these stories and running with them? Yes. Was that your opinion when you told him that? I thought the media was taking a lot of or a little information and making a big deal out of it. Yes. You said it was media speculation? Yes. And was that your opinion as you were talking to Lyle? Yes, it was. And he seemed to be concerned that this image of organized crime, he didn't want that ban- being bandied around. I don't know what that means. I'm assuming from context he didn't want the word getting out about that. Correct. And he never told you it was organized crime, had he? He had not, no. It appeared that Lyle Menendez was concerned about his privacy, didn't he? Yes. And about his family's good name? Yes. And that he wanted to also protect his grandmother from reading these accounts in the newspaper. That seemed to be his major concern, yes. He mentioned that a couple of times, didn't he? That's correct. Concern about his grandmother? Yes. And Lyle himself, Lyle Menendez, told you in this statement, I don't believe the organized crime stuff. Isn't that what he said? Yes. Going to page 32, at that part of the conversation, you asked him about the Rolexes, didn't you? About midway through the page. Yes. And again, a lot of that conversation is unintelligible, isn't it? That's correct. And then you asked him something about the bodyguards? Yes. And you asked him something about that, and he said, well, he felt they were being followed. One of the security people had thought it was the FBI. So remember, they hired security for themselves after their parents uh, were deceased. And then the word in the media was getting around that there were these mafia hits on them. And so they thought that they were in trouble, like they themselves were in fear of retaliation or something. So they hired their own bodyguards to protect them for some time. All right, that's what he said. And that they had suits and were real obvious. He talked to you about that? Yes. And you said that's who's following you? And he said, yeah. Page 33? Yes. And then you said, could it be the media people? The newspaper people? Or the TV people? Also, or actually, Detective Linehan said that, but yes. I'm sorry, your partner said, could it be the media people? Yes. And Mr. Menendez basically said, well, I'd be surprised, but maybe that kind of an answer there. Yes. Then you asked something about how come he'd let the security people go, that he wasn't employing them anymore. Yes. And did Mr. Menendez, in essence, said, well, at first, the company was paying for them, so he'd let them. But when it came to whether he'd pay for them himself, it was too expensive and he let them go. That's correct. These are details I don't recall coming in the first trial. So there's a lot of stuff here that is a little bit different. Um, Now, Was it your opinion at the end of the conversation that Lyle Menendez was trying to point the finger at the mob, the mafia, or organized crime for having done this? I got no impression from him. So that is a good, that's a good response for the defense. Detective Zoeller got no impression from him that he thought it was a mafia hit or anything like that. So no impression from him in that regard. That's correct. In fact, did he indicate exactly the opposite that he did? That he would be surprised if it was yes. Now, later in the day, you talked to Erik Menendez after you finished with Lyle Menendez, right? Yes. And Lyle Menendez was out of the room when you were talking to Erik? That's correct. And then Lyle Menendez came back into the room a few minutes later, didn't he? At some point while you were talking to Erik. I believe it was at the end of the conversation with Erik, but yes, he came back at least before you left that day. That's correct. And at that time, he was wearing a Rolex watch. Yes. The one that you had mentioned earlier. Yes. And you told him basically, gee, don't wear that back in LA. You're going to get ripped off. People rip people off for Rolexes. Yes. Detective Zoeller said that to him in an interview. Mr. Gessler says, thank you. I have nothing further. Here we go. We got Ms. Abramson coming up. Ms. Abramson is going to ask you some questions about the crime scene. Ms. Abramson says, oh, one or two. The court says, all right. Thank you, Your Honor. Ms. Abramson says, good afternoon, Detective Zoeller. Good afternoon. You've been on this case continuously since the early morning hours of August 21st, 1989. Have you not? I have. First of all, I also want to point out the fact that Gessler spent how much time? 15, 20 minutes on the lead detective in the case? Like, you had no other questions on that? But cool. And there were no like follow-up he would ask a question, get an answer, and like not follow up like, well then who did? If it wasn't you, then who did that? He wasn't quite as aggressive in his style as Leslie, I'm sure will be, and I'm here for it, ready for the popcorn. So I'm gonna keep going a little bit longer, and we're just gonna go until I'm tired and I can't talk anymore. Well, we'll go for a little bit longer anyways. All right, so he says he has. And up to that day, how long have you been a detective involved with robberies and homicide cases for the city of Beverly Hills? Since 1980. So that was about 9 years ago? Correct. And over the course of that 9 years, on average, how many homicides did you have to investigate in the city of Beverly Hills? There's a distinction made in Beverly Hills as far as homicides. I handled deaths in Beverly Hills, which includes self deletion, natural, and homicides. We average approximately 2 homicides a year in Beverly Hills. Beverly Hills is one of the wealthiest communities in Southern California, is it not? I would say so, yes. And would it be fair to say it also has among the lowest homicide rate in the state? Yes. So he's probably not really that experienced in homicide cases. He's only done maybe like 2 a year in the 8 or 9 years he's been a cop. That's not a whole lot. And in your experience as a police officer and detective, would you say that homicide cases are those which most require the assistance of identification technicians, of criminalists, of forensic experts? Yes. And is it true that as a sequence of the fact that Beverly Hills has so few homicides every year, the Beverly Hills Police Department does not have its own crime lab? I'm sorry, could you repeat that? Is it a consequence of the very low homicide rate in the city of Beverly Hills that leads to the fact that the Beverly Hills Police Department does not have its own crime lab? I don't think that's the only reason, but you don't have one. but we don't have, no. But do you not have a contractual agreement with the Los Angeles County Sheriff's Office to use their crime labs? Yes. Does the Los Angeles County Sheriff's Office have a well-regarded crime lab? Yes. And do they call it their SID division or Scientific Investigation Division? Yes, I've heard it called that. And do they have this at their location on Beverly Boulevard in Los Angeles? Yes. And do you have, in fact, forensic experts over a wide range of fields? Yes, they do. Do they have full-time criminalists? Yes. And can you describe briefly what a criminalist is? On that, one that studies the aspect of crime, all aspects of crime. The physical evidence? Yes. Is this someone who can draw certain conclusions from physical evidence about the identity of people, about how crimes occur, about what evidence at a crime scene is significant? Among other functions, do they do those three things routinely? Do they do those three things routinely? Sure, that's easy to say. That's a bad question, pretty much, he says. So criminalists can do things like analyze hairs and fibers and blood and prints? Yes. And the Los Angeles County Sheriff's Office, in fact, has people who just do, for example, blood and people who just do hairs and fibers and people who just do prints. Yes. And they have many of these experts in the lab. Yes, they do. Now, what you have at the Beverly Hills Police Department, however, are technicians to collect evidence. Would that be fair to say? Yes. Not people who do the analysis. They don't do the analysis on serology, they do their own analysis on fingerprint work. So serology is blood evidence, correct? Correct. And so bodily fluids such as semen, yes, also bodily fluid. Does Beverly Hills do its own hair analysis? They do not. That's also done by the Sheriff's Department. Yes. That was a question? Did Beverly Hills do their own print work back in 1989? Yes. Did they do their own print work even before there was a statewide computer network for fingerprints that now exists? Yes. And that doesn't have to do much bearing on how they conduct their investigations or their print work because they develop the print and send it to the state's computerized network. So the Beverly Hills technicians, I assume, would prepare the area to dust it to see if there are prints. What are called latent prints? Correct. Your own people do that? Yes. And then your own people do the exact step, which is to lift the print off, which can be done in a couple of different ways. Yes. And then you would then take that print. If they want to run it against the computerized network, they put it on a certain kind of card, align it in a certain way, and send it off to Sacramento? Roughly, yes. Roughly, yes. And if there's a match, Sacramento gets back to you and lets you know that they've matched that print with something in their computer file? Yes. But when there is blood evidence, this is like antiquated. This is technology antiquated in the 1980s. But when there is blood evidence to be, well, let me ask you this. Do your identification techniques even collect blood evidence? Yes, they do. And if it needs to be stored and analyzed, is it turned over to the Los Angeles County Sheriff's Lab? Yes. Now, was there eventually a Los Angeles County Sheriff criminalist who did work on this case? Numerous, yes. Was one of them a gentleman named Ron Linhart? Yes. And is he a civilian employee of the LA County Sheriff's Lab? Yes, he is. Not a deputy sheriff? That's correct. And was there also, by the way, do Beverly Hills police departments have its own ballistics lab? No, we don't. And does it have its own resident ballistics expert? No. So remember how I said, how is Leslie Zoeller testifying on ballistics when he's not a ballistics expert. They don't have a ballistics expert in Beverly Hills. And you don't consider yourself a ballistics expert? Oh, positively not. But he testified to it. So there's that. Okay, so was there a Los Angeles County Sheriff's Department ballistics expert who has worked on this case and in fact testified in this case? Yes. And is that he was a deputy sheriff, is he not? Yes, yes. And is his name Dwight Van Horn? Is is it not? That's correct. At this point in the progress of the case, Detective Zoeller, is the Beverly Hills Police Department the agency that's issuing subpoenas, or is it the district attorney's office? The Beverly Hills Police Department is given the subpoena by the DA's office to issue. Have you subpoenaed Deputy Van Horn? Objection, irrelevant, sustained. All right. So have you subpoenaed Dr. Oziel? Objection, irrelevant, sustained. Have you had any contact with Dr. Oziel since he testified in the first trial? Objection, irrelevant, overruled. Yes. And do you know where he lives? I do not. Do you know what city he's in now? No. Have you talked to his attorney, Mr. Brunin? Objection, irrelevant, overruled. In what period of time? Since the last trial. Yes. So he's talked to Oziel's attorney. He's had contact with Oziel since the last trial. Have you talked with his attorney, Mr. Brunin, in order to locate him, in order to subpoena him? Correction, irrelevant, or objection, irrelevant, sustained. Have you made any effort to subpoena him? Objection, irrelevant, sustained. To your knowledge, is he alive? Objection, irrelevant, overruled. To my knowledge, he is. And to your knowledge, is he healthy? Objection, irrelevant, overruled. I have no idea whether he's healthy or not. This is kind of annoying that they're objecting to everything. They don't want it to come in because they don't want the jury to be like, well, why didn't they call Dr. Oziel? Because he's a terrible witness for the state, so they don't want to call him. I think the defense should have called him, but they don't. But anyways, Oziel, he's got his own problems. She could have. It's harder to discredit them, and you can't really bring them on the stand just to impeach them. But whatever. All right. So Ms. Abramson says you don't have any indication though that he's disabled. That's correct. Let me turn your attention back to the night and early morning hours of August 20th, 21st, 1989. Where were you when you got any kind of call or notification about the double homicide? I was at home sleeping. And did you get your notification by telephone? Yes. And what time did the phone ring? Sometime around 12, midnight. Midnight. And when you received that telephone call, do you know how long after the Beverly Hills Police Department first became aware of these double homicides that you were being called? I believe at the time, I don't recall whether they told me the time of the call. Did you get the impression that they had received a call? Yes, over the 911 network. I don't know how they received the call. I was aware that they'd received a call. And to your knowledge, was the call from someone who claimed he was a resident at the location where the homicides had occurred? At that phone call, the initial phone call, I didn't receive that information. Did you get, have you have any information about, did you get or have any information about how long before Beverly Hills Police Department had received notice? Was it hours before, minutes before, seconds before? I'm sorry, ask me that again, please. Let me ask you this. Since then, have you determined that the contact with the Beverly Hills Department was via the 911 emergency network? Yes. And does the 911 emergency network generate a log of when calls come in? Yes, it does. Did that log indicate that, in fact, the first call came in some 13 minutes before you were called? Roughly, yes. Now, you've told us that the first place you went was the Beverly Hills Police Department, the station. That's correct. And where is that station? The Where is that then? Thank you. It's located or was located at trying to remember the address now. The street will do. Yeah, on Rexford, Crescent Drive at the time, 400 North Block, between the Santa Monica Boulevards. And now it's moved since that time to a new civic center that was in the process of being rebuilt. Yes. What's the address? 464 North Rexford. And approximately how far away from 722 North Elm Drive was the former location of the police department in the 400 North block, yeah, 400 block north on Crescent? Approximately 3/4 of a mile. What time was it that you got to the station? Roughly 1. And how long did you remain at the station before you went to the scene to 722? Just enough time for my partner and I to team up together. Yeah, but how long was that? Not very long, within 5 minutes. Okay, and was it your understanding that that at the same time that you were being called, Detective Linehan was also being called? Yes. Were either of you senior to the other, or were you of equal rank and authority at that point? Pretty much equal rank and authority. And your boss for both of you was Sergeant Tom Edmonds? That's correct. So Sergeant Edmonds does testify in this trial. I will have you guys take a poll to decide if we should read his testimony. Um, Him and Buttkiss. Such a horrible name. Michael Buttkiss. All right, so he says that's correct. And that time, Sergeant Edmonds had been with the department how long? Objection calls for hearsay. If you know, approximately. Approximately 29, 30 years. Is he still with the department? Yes. Still hasn't retired? No. Never will? No. Now, when you got to the station, was Sergeant Edmonds there? I believe he was, although I didn't speak to him. And you don't recall seeing him? I don't, no. Did you gather more information about the nature of the call and who the caller may have been from the scene when you got to the station? Yes. And at that time, did you learn that the son or sons of the owners of the location had placed the call? Yes. And at that time, as far as you knew, had the sons of the owners of the location made contact with Beverly Hills police officers? Yes. Personal contact? Yes. And at about what time, about that time, at about 1 to 1:05 at the station, did you know where the sons were? I believe I did, yes. Where were they? They were in an interview room with Sergeant Edmonds, at least one at a time. Did you see either of them? I did not. No. So he didn't even interview them at this point. So now, but he's the lead somehow. Now, ultimately, did you become aware of the fact that Sergeant Edmonds had had tape recorded conversations with each of the Menendez brothers? Yes. And did you learn that later that morning? Yes. And did you also become aware that Sergeant Edmonds had made a summary of those tape recorded conversations? Ultimately, yes. Did you see, when you got to the station, any potential witnesses to this homicide? Were there any people there at the station, civilian witnesses? No. Were any of the police officers who had gone to the scene in response to the 911 call returned to the station? Were any of them there? Not that I was aware of, no. Did you have any information given to you while you were still in the station by any officers who had gone to the scene with respect to what they had observed while there? I don't believe so, no. This drives me crazy. You're the lead detective, and you should be like one of the first people there on the scene. I don't know if he knew he was the lead at this point, but he is now, and he has a lot of things unanswered. All right, so did you get, apart from the information that it was the sons who had made the call and that the sons were being interviewed by Sergeant Edmonds, did you learn anything about the scene or the nature of the homicide while you were there still at the station? Yes. Okay, and who did you learn it from? Generically. Watch commander. I don't know who it was at the time. And the watch commander is someone to whom the patrol officer would be calling in with information in the early stages of an investigation? Yes. Beverly Hills, the dispatcher sent a number of cars to 722, did they not? Yes. And is it the responsibility of those officers in those radio cars to be calling in, or whichever one of or ones are considered to be in charge of information relay, to be calling in to the station, let the watch commander know what's happening before detectives get there? Yes. And once you, as a detective, got there, then they'd be reporting to you in person. That's correct. Because a detective is in charge of the investigation of a crime like this. That's correct. And the officers who had gotten there before you within that hour and 13 minutes, let's say, what were your responsibilities as far as Beverly Hills Police Department procedure is concerned? And the time at the time they arrived at the scene, these are patrol officers, basically. Yes. They're uniformed officers? Yes. They work in radio cars. That's correct. Okay, and what are their duties when the 911 call goes out and the dispatcher sends this car and that car? What are they supposed to do when they get to the crime scene? Well, their responsibility at first is to determine if, in fact, there's a crime scene. One, they determine that, then they will secure the crime scene for the detectives. Now, what do you mean by the term secure the crime scene? They will make sure that it's not altered in any manner and stay out of it. They're not supposed to go tramping around through the crime scene disturbing evidence. Correct. They're not supposed to be opening cupboards or drawers or looking around under beds or doing anything like that. Well, they will do that if they think there's a suspect in the house. They'll open up cupboards and look under beds. But if they're told there's no suspect in the house or no reason to believe there's a suspect, then they're not supposed to do that? Correct. And are they supposed to move things around from one part of the house to another part of the house where a crime scene has occurred? No. That's pretty basic training for you, officer, isn't it? Yes. Or that's pretty basic training for, yeah, it's basic training for any officer. He says yes. All right. So, is it then your training and their training that the evidence located at a crime scene can often identify the perpetrator? Yes. Is it important to identify perpetrators so that you can arrest people and prosecute them so that the justice system can click in? That's the whole idea. And that's why you don't want people messing around with the crime scene. Correct. And there's a very simple device that your Beverly Hills department and other police departments use to keep other people, strangers of any kind, out of the physical setting of a crime scene. Yes. And is that yellow tape? Yes. And everybody is used to that now. It's got police printed on it. Police crime scene. Yes. And when you got to the crime scene, which I take it for the moment is the whole house, is considered in a large context to be the crime scene. Actually, at the time, the whole property at 722 North Elm. So the whole property, not just the house. I meant that, but you said it better. The property lines from the very front to the back, side to side, is the crime scene. That's correct. And when you got to the house and you think you got there, what, about 105, 106, something like that? Somewhere around there. Okay, was there yellow police crime scene tape strung around the property? Remember, the brothers didn't get home till like sometime after 10, and that's when they called 911. So it's now 1 in the morning that the lead detective is just getting there. So that is kind of like, why is it taking them so long to get there? But anyways, all right. So the crime scene. Okay, was there yellow police crime scene tape strung around the property? Yes. And do you recall what it was strung around? I mean, physically, what do you hook it to? What was the hook? What was that hooked to into this case? I don't recall the back, but I remember a tree in the parkway, and it was strung from probably the fencing on the north side of the property, the northwest side to the tree to the southwest side. Let me see if I can get the property chart. The chart is bigger than I. Turn it so you can see. God, I know. Okay, the court says, where is Mr. Levin when we need him here? That's her, like, co-counsel. Um, Where's those long, strong arms? She says. Mr. Levin says, I'm teaching her independence, Your Honor. Thanks, Chief. Okay. Now, this particular diagram and the others that were newly marked here by Mr. Khan the last couple of days were not prepared by the department. Is that correct? That's correct. They're prepared by someone called Decision Quest? Yes. And by the way, did you consult with Decision Quest in the preparation of any of the exhibits and charts? Indirectly, yes. How indirectly? Well, through the district attorney's office for my input and then to Decision Quest. Oh, damn, you're part of the chart. Okay. All right. So now you were saying I don't have a pointer, but you do, and you can step down at any time. If you would, in fact, do that so you can show the jury where the tape was strung to protect the crime scene. When I arrived, although it doesn't show the parkway, there's a fence that goes to the front of the house with a gate that's actually rolls into itself to the south and the fence all the way around. What I recall is that it came from the north side of a tree to a tree that was in approximately the center of the property, north to south, and then back over to the south edge of the property. Let's do this, says Leslie Abramson. I wouldn't want to mess up such a pretty thing, but let's put a post-it note where you think the tree was. Let's just do that. I'll write tree. And why don't you put that again? It doesn't have to be perfect, just to give the jury an idea. The witness does it. And it was wrapped around the tree, and then did it tie to the fence? Okay, she's asking, did it tie to the fence at either end? He says, I believe so. Okay, so let's indicate that there was a fence at either end. Let the record show that the witness has placed a small yellowish post-it, Your Honor, with the word tree at the place on which is this? It's on that end. These things are so big, the number is up to the top. All right, this is Exhibit 2, Your Honor, and the witness has placed the word tree over the number 70, and the symbol for feet, at which indicated the west end. Oh, they're saying this is exactly where he put the post-it for the record. They're just being very specific. And the symbol for feet at that and at what's indicated the west end of the chart. And he's placed two post-it notes, which with the word fence at each corner of the property of the west side of the property as shown on this diagram. So the tape went across that area of the front so that someone couldn't even, I take it, traverse the sidewalk that separated the parkway from the actual property itself. Yes. Okay. And what separated this property at 722 from the next house over? It was a fence. I don't recall what type of fence. I know on the north side, it's a wooden fence. And it ran all the way it ran a little least to the tennis courts and fence. The tennis courts I don't recall where it was. I don't recall whether the tennis courts chain link fence was in. Either the chain link fence was the boundary of the property where the tennis court split, or there was a passageway between the chain link and a wooden fence. Not a passageway, he says. Right onto each other? That's correct. On the south side, it was your recollection there was fence of some kind of all the way down? Yes, it was It was shrubbery intertwined with the fence. Whether it was wooden or chain link, I don't recall. So did that render the fact that both sides of the property, the north side and the south side, were fenced? Did it make it not unnecessary to put crime scene tape to keep people away? Correct. But at the back, there were two gates from the alley that led back to the property? Yes. And was the court interjects, Ms. Abramson, why don't you get back to the podium? You can inquire from him from where you are. And this was this crime scene tape across the alley. There is to keep people from accessing those gates. From what I recall, it was just the crime scene tape was just around the gate portion itself. Because otherwise there was the chain link fence of tennis court? Correct. So the back wall of the guest house. That's correct. And the garage for the premises is actually at the front of the house. Well, there's two garages. There's one at the guest house and then a single at the front of the house. The one at the guest house, is that accessed from the alley? Yes. And was there any tape across that garage door that you recall? I don't recall. Do you recall what kind of garage door it was? Wooden. Before you left the station to go to the location, did you see an individual named Perry Berman? I did not, no. Did you ever see Perry Berman that morning? No. Were you notified at any time while you were at the crime scene that the Menendez brothers had left the station? I don't believe so. Did you have information concerning how they got there to begin with? At that point? At any point that morning, before you actually met them for the first time, did you know how they got to the station so that they could be interviewed by Sergeant Edmonds? I d- Hold on. The dog transferring beds. Um, he's just noisy. He loves to drag his nails on the ground. All right. He says, I don't recall exactly when I found out, whether it was that morning or subsequent to that day. So someday you found out how they got there. Yes. And was an officer Butkus one of the officers that you met with when you first got to the crime scene? Yes. And was it your understanding from either the 911 call or other official documents of the Beverly Hills Police Department that he was one of the officers at the scene? Yes. And was it your understanding that he observed the means by which the Menendez brothers were transported to the police station? I don't fully know who told me how they were transported. And you don't know, can't recollect now, if Officer Butkus had that information. That's correct. Did you see at the police station Mark Heffernan? No. Did you know who he was? Yes. Was he identified to you at some point as Erik and Lyle Menendez's tennis coach? Yes. And he's one of many that we'll get to. And did you see him at the crime scene? No. Did you see at did did you see seem I think that means did you see him at all that day? I don't believe so, no. So you know if the Beverly Hills Police Department maintained any kind of homicide log or master log that would show the time and the place for every contact with all witnesses that day, August 21st. It is normally done, and at the crime scene, I don't have one, so it was not done. At any time that morning, either before or after you arrived at the crime scene, did you call the LA Sheriff's Department and ask for a criminalist to assist in the investigation of this crime scene? No. Do you know at that time whether or not Beverly Hills Police Department's contract with the Sheriff's Department would have allowed you to do that? No. No, he doesn't know, or no, it wouldn't. You found out later that you could have done that, didn't you? I actually found out through the sheriff's department. It was the sheriff's department that advised me that they would send criminalists out. Do you consider that after Did you consider that after August 21st? Yes. So you didn't know that you could have done that and had a criminalist right at the scene. There. That's correct. So is that why it was only the ID technicians from Beverly Hills PD that collected evidence in the crime scene? Yes. Now, you've talked briefly about the fact that you first met the Menendez brothers at approximately 5:30 that morning somewhere on the property. That's correct. And you don't have a visual image of the meeting. Is that fair to say? At least where it occurred? That's correct. And do you even know if it was outside or inside? I believe I met them at the door, and I have an impression it was at the back door. Well, which one do you mean is the back door? There's lots of doors. The service door. The door to the service porch? Correct. For a moment, dealing with that, when you showed the crime scene video yesterday, was that door to the service porch open during the making of the video? Didn't the camera walk down that walkway and look into the service porch area? He says yes. See, we miss all that because we don't have video. Thank you, Judge Weisberg, for that dumb decision. And when you got to the crime scene, was the door standing open? I don't recall. Were various doors at the location open for the purpose of making the video so that you could see what rooms were abutting, what areas of the outside? Yes. And therefore, the video was not meant to show the precise condition in which those doors had been found by the first officers at the scene. That's correct. When you got to the scene, were any of the doors that led to the outside of the house in a standing open position? One that I recall, yes. And was that the front door? Yes. And was it your understanding that the front door was opened by the Menendez brothers as they left the house? Yes. And your officers observed them coming through that door? Yes. Was there any other door in the house leading to the outside that was in an standing open position when you first got there? Yes. What was that? It was the French doors, at least one side to the living room. And do you know how that door got opened? Yes. And how was it? The officers opened the door. Interesting. That part of their securing the scene? So so that they could go out and look at the outside of the property? Presumably, yes. You were not happy that they did that? No. It was okay? Well, as long as I know what they did, so that you're not misled into thinking that the condition of the premises at the time of the homicide. Correct. And your understanding was that at the time that the first Beverly Hills police officers got to the scene, the living room French door was not open? That's correct. So it is your recollection, you believe that the f- that when you first met the Menendez brothers at the front door to the house, the service porch door. How did they get there? They were escorted by the officer that I presume was at the back of the property. Do you know how they got to the property? I do not know. So somebody drove them back and forth. Were they the officers or family members? Who? Was there a reddish colored Ford Escort parked in front of the house on the street? Directly north of the house of the street, yes. When you say directly north, you mean past the property line, which would be like up here. And she's pointing at the map or aerial view or something. And he says, well, what I recall, it was in just north of the driveway. Whether it was past the property line, I'm not sure, but I have an impression it was just north of the driveway. So the property, as the diagram shows, goes on for a ways north of the driveway. Yes. And that's your impression of where that car was parked? Yes. Did you learn at some point that that car was the car that Erik Menendez drove? Yes. Registered to his parents. At that point, I don't know who it was registered to, but yes. And was that car enclosed in yellow tape? Yes, it was. I might state I believe when I got there, there was actually yellow tape across the street from the east side to the west side, keeping news media away. So the street was blocked? Yes. Wow. Were news media already there when you got there at 1 o'clock? No. But there was police cars blocking the street and they put the yellow tape up. And how long did the tape remain blocking the street? I have no idea. Do you recall that condition with the tape blocking the street still in effect at 5:30 when the Menendez brothers first came to the house? I wasn't outside. I don't know. Okay, so they came and you met them at the doorway to the service porch. I believe so. Did they come in that doorway? They did not. And this is this and this. Oh my God. No, there's no this. And is there a landing or steps there outside the service porch area door? Yes. And were you standing on that landing? If you don't remember, don't guess. I don't remember. Was there a police officer with them? Yes. Who was it? I don't recall. Was it an officer who remained at the scene or had been there earlier or it was someone who just left when they left? I don't know. And did an officer approach you inside the premises to alert you to the presence of the Menendez brothers at the property? Yes. And did that officer say anything to you about why they were there? Yes. And did you then go over and meet them? Yes. And did you tell them basically that you couldn't come in at that time? Yes. Did they repeat to you any reason why they were there, or you just acting on the information that the officer gave you? Both. Now, you testified that your recollection is that they were requesting to come into the house so that they could collect some items. Yes. And one of the items was clothing? Yes. And was it your understanding that they obviously weren't going to stay at the house that night? They were going to go somewhere? Yes. And they wanted clothes? Yes. Do you recall them asking about keys? Keys to the house? I don't recall. Do you recall whether or not you saw any house keys anywhere? Is that what 12 in that 12,000 square foot home? Holy cow. I have a recollection of seeing keys. That's a huge house. I have a recollection of seeing keys, but I don't know where. Whether it was in the bathroom of Mr. and Mrs. Menendez, or in the kitchen, I don't recall. But I remember seeing keys. We heard in the first trial that there were keys in a drawer and everybody had to return it back to the drawer. You could take them if you were leaving, but you had to return it back to the drawer. And because of that reason, like they couldn't own their own keys, so it just became stupid. And then when they would come home, they had to call, knock on the door because the mom would lock them out and things like that. So there was all sorts of problems with getting locked out of the house and not having a key. But she kept it in a drawer in the kitchen, and everyone had to return their keys. It's very, very bizarre. But anyways, all right. He remembers seeing keys. Okay, do you recall, and you don't recall, that you asked for a set of house keys? I don't know. And you said they asked you about tennis rackets or tennis equipment or tennis clothes. I have the impression it was tennis rackets. And had you, by that time, gone through the whole house? Yes. How many tennis rackets did you see? Inside that house? Quite a few. Um, a lot, she says. Yes. In fact, there was a tennis racket lying right in the front entryway that we saw on the video. Yes. And there was at least one tennis racket in a blue case that we saw in a video within Erik Menendez's bedroom. Remember that? I don't, but probably. Okay, and had you locked in the guest house? I'm sorry, had you looked in the guest house at that point by 5:30 on August 21st? I don't know when I looked in the guest house. Eventually, did you look in the guest house? Yes. And were there a bunch of tennis rackets in there as well? Yes. So there were many tennis rackets around the property. That's correct. And did you indicate to the Menendez brothers that they could go in the entryway and get one there, or go up to Eric's room and get one there, or did you tell them that they can't come into the house at all? Well, what we actually requested is, what I did is I asked them, well, where are the tennis rackets that you want? And they indicated that they were in the den. And I said, you cannot go in there to get your tennis rackets, or we'll take them into the portion of the house. Was there a machine of some sort in the den? Yes. And did you know what the machine was? I think it was a racket stringing machine. So they had equipment upon equipment for their tennis game. So there's some machine that they can use to re-string their rackets there that they had. So it's a machine that strings tennis rackets? I believe so. And were there more than one of those in the house? I don't recall. Were there also tennis bags in the entryway? Yes. Were there, by tennis bags, I mean the kind of bags that you would put tennis equipment in, tennis clothes, your tennis balls, tennis shoes. Yes, athletic bags. Correct. Were there athletic bags on the floor of the entryway? Yes. Were there athletic bags on the floor of the den? Yes. Were there athletic bags on the floor of Eric Menendez's bedroom? I believe so. And were there athletic bags in the guest house as well? Yes. And were there shoes, athletic type and tennis type shoes, in all of the rooms? Yes. Now, did the Menendez brothers give you any indication of where they were going to go when you shooed them away at 5:30? He says no. And did you tell them to come back at a particular time? Yes. And what time did you tell them to come back? At approximately 8:30. And did they come back at 8:30? Yes, they did. And did you, at 8:30, allow them into the house? Yes. Were you done processing the crime scene at that point? I believe for the most part, yes. And did they remain at the house for any period of time? Yes. Did they stay there from then on as far as you knew? As far as I knew, yes. Because did you leave? Yes. Did you leave, or are you still there right now? And what time did you leave? Somewhere between 8:30 and 9:30. And did the other officers leave before you or at the time that you did? Which other officers? Well, there were other officers there when you got there. Did they stay all the way up until you left? No, they were actually relieved by the day watch crew that came on. And what time did the day watch crew come on? At that time, I don't recall, somewhere around 7. And when Lyle and Eric came back at 8:30, was there still yellow police tape around the Ford Escort? I don't recall. It could have been taken down by then? It could have been, yes. When you left, was the tape taken down? From the Ford Escort? From the front of the house? I don't recall. Would that be the standard procedure if you're done at a crime scene to take the tape? If we're done, we would generally take it down. Yes. Now, when you're done processing the crime scene, does that also mean the photography has been completed? Yes. And the videotape, if you're going to make one, we saw, I think the times on that was completed by 8:30, was it not? Yes. Was that basically the last thing that was done? The making of the videotape, the last segment of it? The last segment, yes. The videotape was made and it was started and then stopped and then started again and then stopped. Yes. Made over the course of the morning. That's correct. Starting at 2 something, was it? 2:43, I believe. Because it showed at one point the decedents in the den? Yes. And then the next time the camera went back in the den, the decedents were gone. That was several hours later. Yes. That was after the coroner had removed their bodies. Yes. And then the last bit, I think it's quite bright daylight outside, and the little time on the video said 8 something. That's correct. And that timer was accurate, was it not? Yes. Within a minute or two. Yes. I mean, it wasn't saying 8 when it was 4 in the morning. That's correct. When you left between 8:30 and 9:30, did Detective Linehan leave with you? Yes. Did you leave any police officers behind? No. So you all had left. That's correct. And the street was open for traffic again. And yes. Okay. You didn't leave, as far as you know, you have no specific recollection of the tape, but assuming that the tape was taken down as it is your custom, there would be no identification from the outside that it had been a crime scene. That's correct. Do you remember the 5:30 meeting with the Menendez brothers at the doorway to the service porch? At that time, was it light out yet? I don't believe it was, no. Was it lit along that walkway that ran between the house and the tennis court? I don't recall. Do you remember what they were wearing? No. Or the type of clothes? No. How about at 8:30? At 8:30, where were they when you encountered them? They were in the house. I allowed them to come into the house. I believe an officer came to me and said that Erik and Lyle had returned and they were allowed in the house. And did you see them in any particular part of the house? I saw them either in the kitchen area or the foyer area outside of the den, which had the doors closed. And were they standing there, or were they on their way, in passing passages going by? When I saw them, they came up to talk to me. Do you remember now what they were wearing at that time? No. Was there anyone with them? Any adults? Not that I recall, no. And did you ever observe them doing anything with respect to the Ford Escort that was parked on the street? I did not observe them, no. Did you later learn that they had been permitted by one of your morning watch officers to open the trunk of that car and do something? I learned that a relieving day watch officer had allowed them to go in the vehicle, yes. And that was before Beverly Hills police had searched that vehicle. Correct. In fact, did the Beverly Hills police ever search that vehicle? I think after I learned that Erik and Lyle had gone through the vehicle, I had that officer go through the vehicle. And did he find anything of significance? Not to my knowledge, no. Now, you heard statements by both Erik and Lyle Menendez in this courtroom that they removed ballistic evidence from the Ford Escort. That's what they said. Yes? That's what they said, yes. And you did have that verified from officers that they actually did rummage around in the car while it was parked in front of the house? Later that morning, yes. And during that, what time frame was it that morning watch officer, he was unaware of an order that you had made earlier? Yes, because he was relieving a day watch officer. And you had told the officers on duty who were there that night, I take it, not to let anybody near the car? That's correct. But nobody transmitted that to him. That's correct. So they got to do that. Correct. Okay, and when was it that you learned that they had, well, strike that. What time was it that they searched the car as far as you knew? Was it on the 5:30 visit or the 8:30? The court says who are you talking about? Saberson says the defendants. Search the car? Yeah, they rummaged through the car. Let's clarify, he didn't see them do anything. I know. You received information that they had been allowed to go into the car. Yes. At what time had they been allowed to go into the car? Around their 8:30 trip to the house. And when they were inside the house, as far as you know, were they ever searched? No, they were not. Before you searched them at 5 or before you saw them at 5:30, had you had any contact with Sergeant Edmonds in any conversation with him concerning his interviews with Erik and Lyle Menendez that morning? Yes. And did you have any further conversation with Sergeant Edmonds between 5:30 and 8:30 when you saw the Menendez brothers again at the house? I don't believe so. No. When you saw the Menendez brothers at the house at 5:30, in your mind, were they suspects in this homicide? No. When you later learned that they had rummaged in the escort, were they suspects for the homicide? No. When you inspected this house, did you, as the investigating officer, try to make some preliminary or draw some preliminary conclusions about the nature of this homicide? Yes. Are homicides in conjunction with breaking and entering or burglary common? No, they are not. When you go to a homicide scene, do you try, however, to determine whether it was the product of someone breaking in? Yes. Did you do that with respect to this homicide scene? Yes. As far as you know, did you and other Beverly Hills police officers check all windows and all doors to this house? Yes. And did you do that looking for any signs of forcible entry? Yes. And was any sign of forcible entry discovered? No. And in your mind, as the investigating officer, did you form at least the tentative conclusion that this had not been a break in type situation? Yes. Was it your tentative opinion that the decedents, in this case Mr. and Mrs. Menendez, had allowed whoever the perpetrator or perpetrators of the homicide were, had allowed them entry into the house? That was one possibility, yes. Another could have been, I suppose, is somebody could have somehow found a way to sneak in without breaking in an open door, correct, an unlocked door. I mean, the house is so big, you could, I'm sure. Or, like people do, a window open? Yes. This was August 20th. 20th. Hot time of the year? Yes. And a lot of people even in Beverly Hills keep windows and doors open in the summer. Yes. And is that something that your departments find out about because there's burglaries through open windows and doors? Yes. Did you have any thought at all upon hearing that was the sons of the decedents who said that they found the bodies and called the police, that they might have had something to do with it since there was no sign of physical or forcible entry? I didn't have any thought of those lines. I didn't have any thought on those lines at that point, mainly because Detective Edmonds had or was interviewing them, so I didn't form that opinion at all, either way. And after he interviewed them, when he conveyed to you that the nature of his conversations with them at 5 before 5:30, you still didn't have that opinion? That's correct. And was that based at all, and I'm not going to elicit the hearsay, but was that based at all on on what Detective Edmonds told you about his impressions about them? Yes. Was it gunshot residue? It's the residue left from gunshots. Okay, and as an investigative tool for police, is there something called gunshot residue testing? Yes. And what is gunshot residue testing? It's the method where you take the gunshot residue from the hands of an individual and then take it or have it taken to the Los Angeles County Crime Lab and they will see if there's any gunshot residue. He just said you take the gunshot residue. You take swabs of people's hands, um, and it'll show whether they have GSR on it or not. He kind of said that all weird, but anyways. Is the principle upon which that testing is based the notion that when a gun is fired, there are certain cases that are released, and those cases contain particles, generally speaking, of the ammunition? Yes. In a vaporized form? Yes. And that vapor often lands on the hands of the person firing the guns and condenses back into solid form? Yes. And is there a gunshot residue kit that's sort of sticky substance, sometimes on a disc, and you would press that disc around the hand of one person that you were suspicious of with respect to whether they fired a gun, and these little particles would affix itself to the sticky disc? That's correct. And that sticky disc would be in a kit, and that kit would go to the sheriff, and they would figure out if any particles on that disc would be consistent with gunshot residue. That's correct. And that is one way to determine whether someone fired a gun close in time to that time that you're interested in. Yes. Did you have any gunshot residue testing performed on the Menendez brothers at any time in reference to this case? No. And did it ever occur to you to test their hands for gunshot residue? I felt that that was not my call, it was Detective Sergeant Edmonds' call. So who's the lead then? Like, if you're just letting Sergeant Edmonds be the lead, then why isn't he the lead for the whole case? And to your knowledge, he didn't call it either. He didn't have them gunshot residue tested. That's correct. Now, you testified yesterday. Is it only yesterday? I think that when you got to the scene, there were lights on in the entryway. What's marked there as the entryway, correct? Correct. But your recollection is that the den did not have lights on. That's my recollection, yes. Are you comfortable with that, or could you be mistaken? I could be mistaken. And as the investigating officer, part of your job is to assemble, as a file in this case, reports and observations of the officers who preceded you on that scene. So Edmonds, he should be well versed in what happened in those conversations with the brothers if he's the lead. But apparently he doesn't know. He doesn't know a lot. And Leslie just pro- proved pro helped prove that because a lot of things he didn't, they didn't necessarily follow some protocol there. So, anyways, he says that's correct. And at least two of those officers were named Officer Butkus and Officer West. Yes. And are you aware of the fact that both of them in your reports indicate that when they got there, the lights were on in the den? Yes. And when you got there, if the lights were off, then an officer would have had to have turned them off, correct? Yes. Do you know if the light switch, first of all, do you remember where the light switch is from the entryway to the den to illuminate the den? I remember it was on the side or the other side of the entrance doors on the inside. Inside of the den? Yes, and if I recall, it was a dimmer switch. So they could be lowered or raised. Yes. And you said that although the lights were turned on at some point after you entered it, you didn't turn them on. Correct. That means you have no recollection of turning them on? That's correct. Do you have a recollection of anybody else turning them on? No. And when you say turn on, I don't just mean on off. I mean if it's dimmed way down and someone raised the candle power, you don't remember that either. No. Was that switch or switches ever dusted for prints by any of your ID technicians? I don't know. Sir, you are the lead detective. You should know where stuff was collected from. You should have already figured out that if you got there last and there were officers there first, they probably turned the light on and off. All right. Anyways, he says he doesn't know. And to the best of your knowledge, apart from who may or may not have turned off the lights, depending on whether your recollection of on or off is accurate, were you satisfied as the investigating officer after you got to the scene and talked to the officers there that the crime scene was intact? He says, yes. Nothing had been removed? That's correct. And nobody had gone tromping around anywhere near the decedents, or had I know that the officers, in particular Sergeant West, went to the decedents. As far as how close, I don't know. But he was actually the one that determined that they were deceased, and he was the one that pronounced them deceased. Well, he's not a coroner, is he? Okay, and that would be somebody has to do that? That's correct. You can't just say, oh, it's a crime scene. stay back, and there would be living people in the process of dying, and you would have saved them? That's correct. So, is it your department's policy to minimize, to the greatest extent possible, anybody tromping through the scene by having only one person perform that function? Yes. And was Sergeant West the highest ranking person first to enter the house? Yes. Yes. And is he experienced to the extent anybody in Beverly Hills could be in going into homicide crime scenes? Yes. And when you say he pronounced them dead, did he do anything medical with result to them, or did he, upon looking at the bodies, realize that they had to be dead given the injuries that they obviously sustained? The injuries and the eyes being open, fixed, and so on and so forth. No breathing. Okay. As far as you know, though, he didn't touch them. He did not touch them. As far as you know, he didn't, as far as he's aware of, smash any evidence or move any evidence. That's correct. I won't try to take you through the scene today because it's going to take a while, so I'm going to jump around to some other things just briefly. Did you personally observe the two .22 caliber rifles at the house? Yes. And when you observed them, where were they? They were in Kitty's closet. And you recognized the closet there were and you recognized the closet they were in as belonging to Mrs. Menendez rather than Mr. Menendez because they were female clothes? Yes. And you remember now that the guns were in a closet that had mirrored doors, mirrored wardrobes. Yes. And I recall them being on the north end of the closet. Okay. And were you the first person to notice those guns, or did another officer draw your attention to them? The officer that searched the house looking for possible suspects within the house told me that the guns were there. And had they checked them to see if they were loaded or not, or were you the first person to do that? I don't recall whether they told me that they checked it or not. So he does not recall or does not know a whole lot of things. Did you check it? Yes. Now I noticed in the crime scene video that was played yesterday in both Mr. Menendez's closet. Let me get that diagram up for you, the second one. The court says rather than doing that, we'll do that on Monday. Ms. Abramson says, okay. Court says it'll take a while to set that up. Ms. Abramson says, all right, Your Honor, thank you. And then the court says, all right, ladies and gentlemen, we'll be in recess until Monday at 8:30. Don't discuss this matter with anyone. Don't form any final opinions about it. Don't permit yourselves to be exposed to anything about the case in any form whatsoever. Like prosecutors maybe stay off of TV about it. That might be good. Whether it's in the news coverage or the conversation or any other manner. And we'll see you back here on Monday at 8:30. Have a great weekend. And then the jury leaves. The court says, all right, are there any matters that counsel wish to discuss? Ms. Abramson says, yes, Your Honor. He says, okay. Well, when we come back from, the court says, wait a second. Okay, you can start. When we come back from the afternoon recess at 3:30, we got a hand-printed note that said DA update for Monday, 10/16/95. Brian Islamania and Jamie Pisarcik in lieu of the other witnesses they gave us. So the other witnesses that were new witnesses to them. And I asked, well, do I expect there's additional interviews with these witnesses? Are there additional interviews? Are there reports? And Miss Nahara said they're being typed. So she's pulling some BS games with discovery, sounds like. All of the people on the prosecution side are. So now we have to protest this, Your Honor. These are two very crucial witnesses in this case being dropped on us Friday, after we've spent our time and planned our weekend to deal with the other witnesses that we were told about, and I just don't understand, first of all, and they're completely out of order and rational sense of putting on this case. And I just thought, or I just think this is being done to see if they can shake us or throw us, or all we do is cause cause all they do is cause us less and less sleep. But all the answer is that we don't have discovery of anything new with these witnesses. Mr. Islamania will require a significant 402 hearing, I should think, before he's going to be allowed to testify. And so that's just Ms. Towery says, in addition, Your Honor, at 3:55, I received from Ms. Nahara a one-page typed document entitled Conversation with Jamie Pisarcik on 10/12/1995. So yesterday. They spoke with her yesterday and they're getting notes on it just now. Evening notes of Carol Nahara. And it indicates changes in Ms. Pisarcik's testimony, potential rebuttal. One, her conversation with Erik Menendez concerning the fact that Lyle Menendez wore a wig may have taken place around Christmas time. She recalls that during that visit, she saw the show Hurly Burly. She also had lunch with Mrs. Menendez at the Cafe Rodeo and went Christmas shopping. The court says that was all testified to. Ms. Towery says, not these things, these were changes. She said that her conversation with Erik Menendez took place in the spring and she was impeached. The court says, as far as hurly burly and stuff like that was all described. Towery says, although she didn't say she recalls she saw it during that, that's potential rebuttal. However, the case in chief part of the notes indicates that. Number one, she doesn't remember the exact day of her first break with Lyle Menendez. She does not know for certain that it was April 19th, 1989. Number two, when Lyle Menendez asked her to do research for him, he explained that he was working on his own defense. He also started, I think she means stated, something about a man named Paul Mones that either Lyle had read a book or he wanted him Mones as his lawyer, or he wanted Jamie to look up some of this Moan guy's cases. And Miss Abramson says, that's a bit new, Judge, a bit. And Miss Towery says, that's new. It also seems to me, Your Honor, to be also potential rebuttal. I thought that we had litigated this in terms of the division of Jamie Pisarcik's testimony, and my recollection, I'll have to go back and look at the people's representation, but we made a 402 motion to limit her to specific items which were not what we were calling anticipated rebuttal. I think that Lyle Menendez asking her to do research on cases in which abused children were acquitted after claiming that they were molested by their parents is clearly rebuttal, and that was never anything proffered by the prosecution. It's now appeared in the case in chief in its modified version and or amended version. So I want to bring that to the court's attention also and object to the late discovery. There's no reason that we had to get this at 3:55 on the day before they're scheduled to testify. She's been on their witness list since she's been on the case. The court says, okay, let me inquire. The bailiff says, can I interrupt? The court says, yeah, go ahead. There's a pause in the proceedings, and the court continues. All right, let me inquire of the prosecution. First of all, why these witnesses Monday instead of the other witnesses you indicated you'd be calling next? Ms. Nahara says, Your Honor, hold on. Ms. Nahara says, Your Honor, we thought that the witnesses that we indicated we were calling next we would get on this week, and these witnesses have other scheduling problems, which is why they were always planned for earlier next week, or at least they were always planned for early next week when we found out about the scheduling problem. We didn't know this. We thought we would be finished with our first 5 witnesses by now, quite honestly. The court says you're the one that called Detective Zoeller, and the direct examination of Detective Zoeller finished about 3 today. So you're the one who gave a time estimate. You're the one who would have known at least how long his direct examination would take. This is nothing to do with a cross-examination. So it's kind of hard to understand why you would expect to finish Zoeller and these other witnesses by today if you still just finished Zoeller this afternoon at 3. Ms. Nahara says, Your Honor, that was our original plan when we started figuring this out on Tuesday. So we had planned to bring in these individuals that we had put on our list for this week, and we had the time. We figured it would come out to 12 hours, but it didn't. Now, these other individuals have other scheduling problems, but that the court says, which other individuals? And Ms. Nahara says, Mr. Islamania and Ms. Pizarczyk. So we're taking them on Monday, and then we're going to go back to our original list. Ms. Abramson says, We'd like to hear what the scheduling problems are. The court says, All right. Ms. Nahara says, As to the report I don't know if they pointed this out to you, but the report that I gave you really isn't a report. It's just a conversation, notes from a conversation that I had with Ms. Pisarcik last night. Ms. Abramson says, We'd like the original notes, Your Honor. The court says, This is a report of your conversation with her just recently? Yes. The court says, Okay, and it does change her testimony from the first trial if she testifies in conformity with your report. Ms. Nahara says, This is correct. The court says, And is there also a report in the works in regards to Mr. Islamania's testimony? Ms. Nahara says, Yes, there is, Your Honor, but that's been prepared by Detective Zoeller. The court says, Okay, and when would that be ready? Ms. Abramson says, He just left. Mr. Khan says, I just spoke to him about that, and I asked him if we can, even if the report is not ready, whether we can get a copy of his notes and either have them delivered or fax them to counsel's office by today. Ms. Abramson says, By today? I think he went to check on that, Mr. Khan says. Court says, One person speaking at a time. This is not a little chit-chat conversation. Damn. He really woke up cranky today. Ms. Abramson says, I apologize. Mr. Khan says, I believe he went to check on that now to see if someone could get their hands on notes. Court says, Do you have some feeling as to whether or not this report alters in any way the tenor of his testimony from or proffer of testimony that you indicated would be as contained in his earlier report? Mr. Khan says, Well, I don't think that the substance is altered. In fact, we never really got into the substance with him. As you will learn, Brian Islamania is not what you call a cooperative witness in this case. So I can't remember who he is now, but he's a new name. He was not in the first trial. So we're going to definitely hear from him because he's a new character here. But as prosecution just said, he's not a cooperative witness. Apparently, he's had a lot more contact with Ms. Abramson than he's had with me. Apparently, he works in the same building with Ms. Abramson, and he's made it clear he's not very happy about being called as a witness in this case, so we never really got into the substance. But he did make some statements concerning his unwillingness to be a witness in this case that I think are significant, and I'm sure Detective Zoeller has memorialized those statements and they should be turned over to counsel. Court says, Well, it would seem that whatever is contained in those statements might generate some litigation on the scope of his testimony, and also the defense would have an opportunity to digest what it is that you obtained from Ms. Pisarcik that's different from the first trial testimony. What is their situation that makes it so crucial to have them testify on Monday? Mr. Khan says, Well, Brian Islamania, I don't think his situation is crucial at all, as long as we get him in court and have him ordered back. That's my main concern. Pisarcik apparently has some scheduling problem. And then the district attorneys are whispering to one another. Ms. Nahara says, Apparently she told us she's going to be unavailable after Thursday. We wanted to get her in the early part of the week. I believe she's available up to and including Wednesday. The court says, What does it mean, unavailable? She drops off the face of the earth for the rest of the trial? And Mr. Khan says, To tell you the truth, I don't know what the problem is she discussed it with Detective Zoeller, I think. I received word of the fact that she wants to get on early next week. Court says, all right. Well, it seems to me the purpose of giving notice to the other side of the order in which you call witnesses is to at least give them some opportunity for preparation as well as scheduling for hearings relating to proposed testimony. They're totally just trying to bamboozle the defense and call people out of order and throw them off their game so that they're not prepared. I see it. It's like a total strategy. It's a tactic, and it's pretty crappy that they're doing this. He just said it's not crucial for the one guy, and the other one is just for preference. So whatever. As far as Islamania is concerned, my feeling is that there might be some need to litigate the scope of his testimony. Perhaps we won't know more about that until Zoller finishes his report. I certainly would be willing to order him back and do whatever we have to do for scheduling purposes. As far as Pisarcik is concerned, if you can give me more information about her status, I don't see a problem in scheduling her next week. It doesn't have to be on Monday, however. First of all, Zoller is still on the witness stand. How long is his cross-examination going to be? The court talking? Oh, Ms. Abramson says, that was Mr. Khan, sorry. So Ms. Abramson says it's easily going to be another 3 hours. We're going to go through all the evidence in detail, open many of those envelopes so the jury can see it. The court says you still have these patrol officers available and these others other witnesses that you've identified. So I'll permit the defense to get into Pisarcik or the prosecution to call her on Tuesday and give them an extra day. But again, these last minute changes, unless they're mandated by changing circumstances that you become aware of at the last minute, they just create dislocation for both sides. It works both ways. When the defense is presenting its case, I'm sure you'll want to know in advance who their witnesses will be so we won't or don't have this sort of controversy. It really is needless. Stop doing it, prosecution. Ms. Abramson says, Your Honor, there's still an issue with respect to Ms. Pisarcik, and I don't think extending it to Tuesday solves that issue because I'm not sure that we'd be in a position to properly cross-examine her if the people are now changing what they're offering in their case in chief. This attempt to impeach Lyle Menendez on whether or not he's abused before he even gets to testify about it. That should have been litigated way back when. Lyle does not testify in this trial, so I don't know if they know that yet, though. Seems like they don't. So, um, she's saying that it before he gets to testify. Okay. So it's clearly a rebuttal issue, his having her research child's abuse cases unless and until he gets on the witness stand and proffers that as his defense. The court says, Did you intend to offer that in your examination of Ms. Pisarcik at this time in your case in chief? Ms. Nahara says, That was our first intention. However, I will go back and look at the ruling that was made on her because if it was set for rebuttal, then it's set and I'll relook at it. The court says the ruling was based on what the offer of proof was. I don't recall that being part of the offer of proof. Ms. Nahara says, I'm not sure, Your Honor, and I don't want to say it until I look. The court says my recollection is the offer of proof had to do with the conversation in the jail. Ms. Nahara says, that I know is true. The court says that's all I recall. So Lyle had a phone conversation with Jamie about apparently about researching CA, and so now that's coming in, I guess. But it affects him then later because he asked Jamie and he asked another friend of his to lie for him on the stand. I don't know that if they know that yet. Maybe this comes in later, but eventually because of that, they're like, well, Lyle's too much of a risk because he can't really be trusted now because all this other stuff came out. They don't put him on the stand. So I wonder if this affects um, the trajectory of whether or not Lyle does testify. Mr. Harris says, I'm not sure, Your Honor, and I don't want to say. The court says my recollection is the offer of proof had to do with the conversation in jail. That's uh, that I know is true. That's all I recall. That could very well be. I'm just saying, Mr. Harris says. And the court says, let's deal with it on Monday. Make sure you have enough witnesses to fill in Monday and you have people on call and ready to go Tuesday and for the balance of the week that you have a list on Monday of who your witnesses will be. All right? Anything else at this point? All right. Let's clear the courtroom. I want to talk to counsel about some matter dealing with some request. And then that is sealed. So we don't have that argument, whatever that is. So that is the entire day of October 13th. That's day 3 of trial. That was the end of direct examination of Leslie Zoeller and the beginning or cross examination from Lyle, which was teensy tiny. And then we're going to go another 3 hours with Leslie Abramson questioning Detective Zoeller. So I look forward to it. I look forward to her questioning. She does. I like her. I like listening to her kind of trap people in questions. It's fun. Anyways, so that is what I have for you for this episode, and I'm glad I got through a whole day in under 4 hours. And I will see you guys in the next one. Please be sure to subscribe and hit that like button on your way out. Let me know what you guys think, what questions you have, what do you want to know. Let me know. Be sure to vote on the polls as they come through, and let me know if you want to hear from Christine Nye, the 911 dispatcher, who's up next after Detective Zoeller. Thank you guys, and I will see you in the next one. Take care. Bye now.